Hello everyone, welcome to Sandpaper-Academy for Civil Services. আপোনালোকৰ প্ৰিলিমছ পৰীক্ষা আহি আছে। I hope সকলোৰে already preparation হৈছে, revision complete হৈছে। So পলিটিৰ কাৰণে মই ভাবিছো ইন্ডিয়ান পলিটিৰ কাৰণে কিছুমান ইম্পৰ্টেন্ট কোৱেশ্চনছ আপোনালোকৰ লগত ডিসকাস কৰোঁ। MCQ top 100 MCQs বুলি ক'ব পাৰে বা খুব ইম্পৰ্টেন্ট MCQs খিনি মই আপোনালোকৰ আগত লৈ আহিছো। গতিকে আপোনালোকে ৰিভিজনৰ লগতে chapter wise যদি অলপমান MCQs খিনি প্ৰেক্টিস কৰি দিয়ে I hope definitely আপোনালোকৰ কামত আহিব। So before begin মই আপোনালোকক ইনফৰমেশন এটাও দিব খুজিছো যি সকল একেবাৰে নতুন এসপায়াৰেন্ট বা যি সকলে ভাবি আছে যে তেওঁলোকে প্ৰপাৰলি APSC প্ৰিপাৰেচন কৰি পেলাই নেক্সট ইয়াৰ অৱতীৰ্ণ হ'ব। তেওঁলোকৰ কাৰণে মই ক'ব বিচাৰিছো যে আমাৰ Sandpaper-এ প্ৰ্যাকটিক্যালি 1:1 মেন্টৰশিপ অফাৰ কৰে এন্ড আপোনালোকে ডেফিনেটলি আমাক কল দিব পাৰে ইন 7638032775 এই নাম্বাৰটোত। আমাৰ এডুকেশনাল কাউন্সিলৰে ডিটেইল আমাৰ প্ৰগ্ৰাম ডিটেইলছটো আপোনালোকৰ লগত শেয়াৰ কৰিব আৰু সকলো ষ্টুডেন্টছৰ আমি ভাবাৰ নিচিনাকে সকলো ষ্টুডেন্টছৰ নিজা কিছুমান ৰিকুৱাৰমেন্ট থাকে। সকলো ষ্টুডেন্টছে নিজৰ নিজৰ ৰেসপেক্টিভ ফিল্ডত কিছু ইমপ্ৰুভমেন্টৰ দৰকাৰ থাকে। সেই গুটেখিনি যাতে আমি কেটাৰ কৰিব পাৰো ডেফিনেটলি ইউ শুড জয়েন Sandpaper-Academy। সো আমাৰ যোনটো মে জুন বেচ হয় এটো স্টাৰ্ট হ'ব জুনৰ পৰা স্টাৰ্ট হ'ব আফটাৰ প্ৰিলিমছ এক্সামিনেশন। ৰেজিষ্ট্ৰেচন ইজ গোইং অন এন্ড মই বিচাৰো যে আপোনালোকৰ যি সকল খুব সিৰিয়াস যি সকলে ভাবিছে যে ভৱিষ্যতে এজন সুদক্ষ প্ৰশাসনিক বিষয়া হোৱাৰ মন আছে তেওঁলোকে ডেফিনেটলি আমাক জয়েন কৰিব পাৰে। সো আমি ফাৰ্স্ট কোৱেশ্চনটো স্টাৰ্ট কৰো আপোনালোকৰ আগত। তো প্ৰথমত আমি কিছু এক্টৰ কথা ডিসকাস কৰিম। তো কনসিডাৰ দা ফলোইং স্টেটমেন্ট ৰিগাৰ্ডিং ৰেগুলেশন এক্ট অফ 1773। সো ৰেগুলেটিং এক্ট 1773 সাপেক্ষে কোনকেটা স্টেটমেন্ট কাৰেক্ট হয়। এতিয়া মই ভিডিওটো স্টাৰ্ট কৰাৰ আগতে আৰু এটা কথা কৈ লওঁ যে আপোনালোকৰ সদায় যেতিয়া কোৱেশ্চন পেপাৰত প্ৰিলিমছত পৰীক্ষাত বহিব তেতিয়া হলে আপোনালোকে দুটা সেন্টেন্স খুব মনত কৰিব। কি হয় কেতিয়াবা এই যোনটো ফাৰ্স্ট সেন্টেন্স থাকে ইয়াতে খুধে কি হুইচ অফ দা ফলোইং ইজ কাৰেক্ট অৰ নট। সেকেন্ডলি যদি ইয়াতে নুখুধে তেতিয়া আপোনালোকৰ সিম্পলি আহে যে কনসিডাৰ দা ফলোইং স্টেটমেন্টস। ঠিক আছে, তেতিয়া কোড খুধে তলত খুধে হুইচ অফ দা ফলোইং স্টেটমেন্ট ইজ কাৰেক্ট অৰ নট। সো যেতিয়া আপুনি চাই লব যে কাৰেক্ট কৰিব কাৰেক্ট অপশন কেটা বিচাৰিব দিছে নে ইনকাৰেক্ট অপশন কেটা বিচাৰিব দিছে সেই হিচাপে আপুনি যেতিয়া কোৱেশ্চন কেটা বা স্টেটমেন্ট কেটা ৰিড কৰিব তেতিয়া আপোনাৰ মাইন্ডে অলপ সোনকালে ক্যাচ কৰিব। সেকেন্ড ইট উইল সেভ ইউৰ টাইম। ওকে, সো লেটস বিগিন। So 1773 রেগুলেশন অ্যাক্ট মতে কি বুঝাইছে রেগুলেটিং অ্যাক্ট মতে কি বুঝাইছে ইট কনসিডার্ড গভর্নর জেনারেল অফ বেঙ্গল এজ দ্য গভর্নর জেনারেল অফ বেঙ্গল এজ দ্য গভর্নর জেনারেল অফ ভুলে হল। সো ফার্স্ট কোয়েশ্চন তো যদি আপোনালোকে চাই তেতিয়ালে রেগুলেটিং অ্যাক্টৰ কথা সুধিছে 1773 ফার্স্ট অপশন তো দিয়া আছে যে ইট ডেজিগনেটেড গভর্নর অফ বেঙ্গল এজ দ্য গভর্নর জেনারেল অফ বেঙ্গল আৰু এক্সিকিউটিভ কাউন্সিল অফ 4 মেম্বার্স ওয়ার ক্রিয়েটেড টু অ্যাসিস্ট গভর্নর জেনারেল অফ বেঙ্গল। হেতু নাম্বার 1 পুদিছে। নাম্বার 2 গভর্নর অফ বোম্বে আৰু মাদ্ৰাছৰ যিসকল বোম্বে আৰু মাদ্ৰাছৰ যি কেজন গভর্নর আছিল তেওঁলোকক গভর্নর জেনারেল অফ বেঙ্গলৰ সাবঅৰ্ডিনেট হিচাপে প্লেস কৰা গল। Number 3 it introduced diarchy in the provinces of Bengal and Bombay. So this statement cannot be correct কারণ ইয়াৰ কাৰণে এখন বেলেগ এক্ট আছে আৰু আমি হেতু আমাৰ এক্সপ্লেনেশনত চাম। আৰু কি হৈছে it prohibited company servants from engaging in private trade or accepting presents or bribes from the natives. যদি আপোনালোকে কেয়ারফুলি কোয়েশ্চনস কেটা চাই তেতিয়াহলে আপোনালোকে গম পাব যে this option is correct, the second option is also correct, third option is not correct and fourth option is correct. So here option A 1 2 and 4 are correct. So আমি এক্সপ্লেনেশনত যদি যাও রিগার্ডিং ডায়ারকি আপোনালোকে হয়তো জানিবই যে ডায়ারকি was introduced by Government of India Act 1990. Okay, so this is also important, that's why এই স্টেটমেন্টটো আপোনালোকে নোট কৰিব পাৰে। So we'll move to the second question. Peace India Act or বিষয় আহিছে Peace India Act 1784. This is also one of the very important act. So ইয়াতে কৈছে কি question number 1 ত কৈছে কি it created a new body called Board of Control to manage political affairs. Okay, the Court of Directors retained the control over military and civil administration. So this option is wrong. আমি explanation of some ইয়াৰ কাৰণ this act marked the beginning of British government's direct intervention in Indian governments. তাৰ মানে এই একখনৰ পৰাই ব্ৰিটিছ সকলে ইণ্ডিয়াৰ গভৰ্নেন্সত ডাইৰেক্টলি ইন্টাৰফেয়াৰ কৰিব পাৰিছিল। ঠিক আছে, it abolished the dual system of governance established by the regulating act of 1773. So ইয়াতে যদি চাই আপোনালোকে option 1 and option 3 are correct, this is not correct. ঠিক আছে, so if you go to the explanation then you will see why statement 2 is not correct, because civil and military affairs came under Board of Control. ঠিক আছে, not Court of Directors. Next, Dual system was formalized, not abolished. So horu kisman kotha thake kisman term thake, that's why while reading the statements please be very careful in case of Indian polity. Indian polity junbilak statement based questions thake hebilak olopman difficult thake ba hebilak olopman apnaloke olopman time loi pela bhabi pela question korar answer koribo. Okay, next we will go to the question number 3. ebar ami ahi golu Charter Act of 1813. Charter Act 1813, 1833 aru 18 this one 1813 aru 1833 is very important. Also you should look on 1853. ekta ek charter apnaloke bhalke poribo lagibo, thik ase. So 13 ot ki hodise, it abolished trade monopoly of the East India Company in India except trade in tea and trade with China. Number 1, this is right. Number 2, it asserted the sovereignty of British Crown over the company's territories in India. So British Crown or sovereignty to Indian territory, company's যিখিনি territory আছিল India তাৰ ওপৰত প্ৰিলেভেন্স হল বা তাৰ ওপৰত assert কৰিলে, ঠিক আছে. This statement is also correct. It permitted Christian missionaries to come to India to promote religious and social reform. This statement is also correct. Then it made provisions for allocating funds for promotion of Western education in India. So India Western education promotion or karoneo this significant efforts were made in Charter Act of 1833. So all of the above statements are correct here. Next we will go to the question number 4. Regarding Charter Act of 1833, which of the following statements are correct here? It made Governor General of Bengal as the Governor General of India, okay, and give him but vested him both civil and military powers. This is right. Next, it deprived the governors of Bombay and Madras of their legislative powers. So they do not have, basically they did not have legislative power, lawmaking power, deprived kor dile. It ended the commercial functions of East India Company, making it a purely administrative body. Very significant act, very significant act, very important act. Okay, please keep that in mind. Okay, all the 3 statements are correct. Last to sound, it introduced provincial autonomy in India. This is not correct. So 1 to 3 option are correct. So A option is correct here. So why the last statement is not correct? Because it was, this act centralized the administration, not introduced the provincial autonomy. Okay, ঠিক আছে. Regarding Charter Act of 1853, which of the following statement are true? Kunketa statement Charter Act 1853 mote correct etia eketa hodise. Okay, so question number 1 is that for the first time Indians were included as the full-time members in the Governor General's Council. So this statement cannot be correct, not as a full-time member. It marked the beginning of parliamentary control over the Indian civil service recruitment process. This is correct. ঠিক আছে. Number 3, the legislative wing of Governor General's Council now included legal experts and representatives. This statement is also correct. And last one, the act retained companies' commercial privileges in India. It was scrap backed already. It was scrap backed in 1833 Charter Act konot. Hone gotike etu to correct hoboi nware. Next, Indians were appointed as non-official members, not full-time council members. ঠিক আছে. Next, we are moving towards question number 6. Question number 6 ot ki koise, Government of India Act 1858 or report question udise, which of the following statements are correct? Yate ki koise, it provided that henceforth was to be governed by India, henceforth was to be governed by and in the name of Her Majesty British Crown. ঠিক আছে. It changed the designation of the Governor General of India to that of Viceroy of India. So single question ketiaba ahibo pare ba double statement based question to ketiaba enuka question apnaloke pabo pare. ঠিক আছে. It ended the system of double government by abolishing. So double government to come by board of direction and board of director and board court of directors and board of control. So it abolish kori disile. ঠিক আছে. It constitute the secretary of state in council as a body corporate capable of suing and being sued in India and in England. So this all the 4 statements are correct here. Next we will consider the question number 7. Morley Minto reforms বা Indian Council Act of 1909. This is also important. Okay. It considerably increased the size of legislative council both in central and provincial. Okay, this statement is correct itself. It retained the official majority in central legislative council but allowed the provincial legislative council to have non-official majority. This statement is also correct. Okay. It provided for the first time association of Indians in the executive council of the viceroy and the governors. So, here is a very important Indian person or name hai. Okay, so their name to muk. Please, apna loge comment box ot janabo. Okay, aru ki hisabe teketok include kora goisile. Aru kar council ot include kora goisile. Okay, it introduced a system of communal representation for Muslims by accepting the concept of separate electorate. So, all the four statements are correct here. Okay, so next question. July 8, 1946 Congress Party, that is Indian National Congress, ki korisile expert committee ekhon constitute korisile for purpose of preparing material for Constituent Assembly. Ei committee kunjon not a member nohoy hetu ullekh korise. So if you have studied about it, then you will get to know that Dr. B.R. Ambedkar was not a part of it. So not jehetu dise option D is correct here. ঠিক আছে, so we will see who are the members of this committee. Okay, so Jawaharlal Nehru was the chairman of this committee. M. Asaf Ali, K. M. Munshi, N. Gopalaswamy Iyengar, K.T. Shah, Gadgilji, Humayun Kabir, Santhanam, K. Santhanam. ठीक है, later aru eta important, these questions also may come. The chairman of this committee, their proposal or ভিত্তিত কি হৈছিলে, Krishna Kripalani co-opted as member and convener of this committee. Okay, convener of the committee kon hoy gol Krishna Kripalani. Okay, next, consider the following statements. Aru ami last chailam which of the following are the reasons for length of Indian Constitution. Bharatiya Sangvidhanor length jehetu olop ami vast hoy na constitution kihor karone hoy, which are the reasons. So tar upor questions ahise. Geographical factors such as vastness and diversity of the country, definitely right. Historical factors, influence of the Government of India's Act 1935, apnaloke hoyto pohise All India Federation and all, tar features bilak gotekhini pohise. There are lots and lots of features that have been included in Government of India Act 1935. So definitely this option can be also correct. The existence of single constitution for both center and states. Hoine amar ekhone constitution ase center or state or karone. The dominance, so some provisions may be repeated. The dominance of legal luminaries in the Constituent Assembly led to an elaborate and detailed drafting style. Okay, so all the above statements are correct here. Next, Article 368, very important amendment, very important. Okay, so ki koise Article 368 of consider kori pelai koise which of the following statements are correct. Some provisions can be amended by special majority of parliament. Special majority mane ki 2/3 of the majority of the members present and voting and the majority of the total membership in each house. ঠিক আছে, aru Article 368 under ki koribo pare special majority of the parliament plus half of the ratification of the states. Etu apnaloke pohise. So these are the only two provisions that are mentioned under Article 368. Some provisions can be amended by simple majority also, but this is not included under Article 360. So option 1 and 2 are correct here only. Okay. Okay. So last sentence to mon koribo. At the same time, some provisions of the Constitution can be amended by simple majority of the Parliament in the manner of ordinary legislative process. But notably, these amendments do not come under Article 368. Right. So next we will move to the question number 11. Parliamentary government in India কোন কেটা ফিচারে রিপ্রেজেন্ট করে তার উপর কোয়েশ্চন আছে। Collective responsibility of executive to the legislature, membership of ministers in the legislature, this is correct also. Leadership of prime minister or the chief minister, that means leadership কাৰ উপর এটো এজন হয় কি হয় ইউনিয়ন কাউন্সিল অফ মিনিস্টার আর চিফ মিনিস্টার স্টেট কাউন্সিল অফ মিনিস্টার, right? Rejection of nominal executive, Do we reject nominal executive? No, we have nominal executive. ঠিক আছে, আমাৰ প্ৰেসিডেন্ট, গভৰ্ণৰ আছে, আমাৰ চিফ মিনিষ্টাৰ, প্ৰাইম মিনিষ্টাৰো আছে। তো আমাৰ ৰিয়েল এক্সিকিউটিভ আৰু নমিনেল এক্সিকিউটিভ both আছে। This is one of the important parliamentary feature. Majority party rule, collective responsibility of executive to the legislature, and membership of the minister in the legislature, then leadership of prime minister or the chief minister, dissolution of lower house, that is popular house, that is Lok Sabha, by assembly, state legislative assembly. So these are the important features of parliamentary system in India. Okay, next we'll move to the next question. Fundamental rights or regarding question ahe fundamental rights DPSP. So প্ৰথমত খুদিছে not correct to আপোনালোকে চাই ললে। then fundamental rights under part 3, fundamental rights or আন্ডাৰত কি কৈছে ইয়াতে rights কেটা দি দিছে, ইপিনে article কেটা দি দিছে, কোন কেটা correctly match নহয় এটো খুদিছে। ঠিক আছে, so which are not correct? Okay, this is correct, right to equality from article 14 to 18. ঠিক আছে, next right to freedom 19 to 20. okay, এটো আপোনালোকে correct পাব। right to freedom of religion article 23 to 24, this is not correct, this should be 25 to 28, and right to exploitation should be article 23 to 24. so option 3 and 4 are not correct. among not correct বিচাৰিব দিছে, একাৰণে আমি that is where you will have to concentrate whether it is asking for correct or not correct. okay, ठीक है, so right to equality covers under 14 to 18, right to freedom 19 to 22, exploitation 23 to 24, right against exploitation, right to freedom of religion article 25 to 28, cultural and educational right article 29 30, aru right to constitutional remedies, that is article 32. so fundamental rights or jiman keta article ase apnaloke eneo monot rakhato khube joruri. okay, question number 13, which of the following is or are not correct? again fundamental rights or question disu, very important. fundamental rights are meant for promoting the idea of political democracy, definitely right. aru eta kotha apnaloke jane DPSP is for social and economic rights by economic democracy, hone economic justice, aru fundamental right is for political democracy, this is right. these are non justiciable in nature, so not correct kudise, this is justiciable in nature, you can directly go to the Supreme Court even if your rights are violated. ঠিক আছে, so they cannot be curtailed or repealed by the parliament through a constitutional amendment act, so this is also not correct. they can also be suspended during the operation of a national emergency except rights guaranteed by article 20 and article 21. ঠিক আছে, so option 2 and 3 are not correct here. option 2 kotha to moi already kolue হয় নহয়, option 3 to kotha sauk, the fundamental rights are not absolute and subjected to reasonable restriction, they are not sacrosanct in nature and can be curtailed or by repealed by parliament through constitutional amendment act. so what happened to right to property? have you heard about right to property? right to property ki asile, FR asil under what article? comment box mok janabo. now it has become a legal right, legal right hoy na noy? so under which constitution amendment act curtail kori court pass korisile, under which article? you will have to know it. ঠিক আছে, next, which of the following is or are not correct? directive principle of state policy kotha hodise, so it was enumerated in part 4A of the Indian constitution, this is not correct, this is in part 4. the directive principles are meant for promoting the idea of social and economic democracy, this is right. they are non justiciable in nature, this is also right. okay, just state has to state should make, but state should have the endeavor to consider this directive principle of state policy while making plans and policies for the welfare of the people of India, but if they are not considered, it is non justiciable in nature. already DPSP class apnaloke hoyto poise. they imposes a moral obligation on the state authorities for the application, this is right, it has a moral obligation, but they are not justiciable in nature. so here okol one question to ami wrong paise, this is option 1 is correct here. okay, so according to the Ambedkar ji, DPSP je noble feature of Indian constitution part 4 ot ase. okay, aru eta important cases or reference moi yate di disu, in Minerva Mills case in 1980 Supreme Court ki koisile je Indian constitution is founded on the bedrock of balance between fundamental rights and directive principle of state policy. Now some directive principles are also now becoming a fundamental rights. If you have studied carefully, then you will see the education to keneke right to education keneke loi aisile amar kun constitution amendment act under to aisile agote DPSP code place hoy asile, why it was shifted from there to there. Okay, baru etu ensure koribole amar ki aisile right to education act aisile. So I hope apnaloke ekhini porise, so moi just ebar bujai dilu. Next, which of the following is or are not correct? The original constitution did not provide the fundamental duties of the citizen. Not correct horise. So this is yes, not correct. Tamane etu option consider no hoy. These were added by 44th Constitutional Amendment Act 1978. This is wrong because this is included in 1976 by 42nd Constitutional Amendment Act. Okay, this should be kept in mind. They are non-justiciable in nature, right? They serve as a reminder to citizens that while enjoying their rights, they have also have to be quite conscious of their duties they owe to the country, their society, and their fellow citizens. Fundamental rights apnaloke enjoy kori ase, but it is also important for you to contribute towards the society. That is why the provisions of fundamental duties were included in the Indian Constitution. Thik ase? So here wrong option is option 2. Okay, আৰু এটা চাই লওক ৰিকমেন্ডেশন অফ স্বৰাজ সিং কমিটি, এটো আপোনালোকে মনত ৰাখিব। 42nd Constitution Amendment Act and on the recommendation of Swaraj Singh Committee, these were included. Next question, question number 16. Correctly match কোন কেটা হুদিছে, হেফালে দি দিছে provisions খিনি আৰু হেফালে দি দিছে article খিনি। ঠিক আছে, the state shall not deny any person equality before law and equal protection of law under article 14. Okay, which of the following are correctly matched? Yes, this is correctly matched. Equal opportunity of all citizens in matters of public employment. সকলো citizen যে public employment or ক্ষেত্ৰত irrespective of his caste, creed, race, religion, equal opportunity jate paয়, hetu kune ensure koribo article 15. This is right. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate freedom of religion. Yes, article 25. No person shall be compelled to pay any taxes for the promotion of particular religion. That is article 27. So all of the above statements are correctly matched here. Okay. Okay. So these are the secular feature or secular character of the Indian state. So here before the term secular was added to the preamble by 42nd Constitution Amendment Act of 1976. Okay. The preamble secures to the citizens of India liberty of belief, faith and worship. Then the state shall not deny any person the equality before law or equal protection of the laws under article 14. We have ekhini amar correctly match ase, gotike already we have told you all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religions. That is under article 25. Okay. Next we will also these provisions are moi aru olop include kori disu. So if you want this PDF and then I will also give you. Okay, so match the following. Question number 17 ot ki koise schedule bilang match koribo dise provision or logot. Okay, so second schedule provisions relating to the emoluments, allowances and privileges. So this is correctly matched. Okay, then fourth schedule ot ki koise division of power between union and the states. No, this is 7. This should be 7th schedule. So option this one is correctly matched here. 3B. Fourth schedule of ki asile amar allocation of seats in Rajya Sabha. So this is allocation of seats in Rajya Sabha. Okay. Aru 8th schedule definitely languages. So here option B is correct. All the schedules from 1 to 12 you will have to remember mandatorily. ঠিক আছে? Okay. So fourth schedule kotha saok, allocation of seats in Rajya Sabha to the states and the union territories. Seventh schedule division of powers between union and states in terms of list. Union list to be so center can make law over union list, state can make law over state list. Aru concurrent list both union and state in certain matters. Now in which are the provisions jot state list or uporot union government or central government law make koribo pare. In what circumstances বা which circumstances সেই বস্তুখিনি আপোনালোকে I hope পঢ়িছে আৰু নোট কৰি লৈছে। So questions may also come that way also. ঠিক আছে। Next question number 18, which of the following are কি দিছে ইয়াতে incorrectly matched? Government of India Act, parliamentary government, no. British Constitution, removal of Supreme Court and High Court judges. This cannot be correct. US Constitution, parliamentary privileges, not correct. Irish Constitution, emergency provisions. So all of the above are not correctly matched. So here option D is correct. Now we will see what are mentions in this respective acts or this constitution. Government of India Act of Sabo apuni Federal Scheme, Office of the Governor, Judiciary, Public Service Commissions, Emergency Provisions and Administrative Details bilak ase. British Constitution main regarding parliamentary government, rule of law, okay? So legislative procedure, single citizenship, cabinet system, prerogative writs etc. were mentioned. Writs or kotha ahibo pare, prerogative writs or kotha kot mention ase, okay? US Constitution ki ase? Fundamental rights, independence of judiciary, judicial review. This is very important, judicial review. What is judicial review? Please write me in the comment box, okay? Impeachment of president, removal of Supreme Court and High Court judges. This time removal of Supreme Court judges, removal of High Court judges is important this time. And jehetu apnaloke procedure khini saboi, etu side hobo je removal of judges you kunkhon constitution or pora lua goise, thik ase? Irish Constitution, directive principle of state policy, nomination of members to the Rajya Sabha and method of election of the president. These were taken from Irish Constitution. Okay. So next we will go to the question number 19. Which of the following is or are again not correctly matched? Okay. Equality before law, Article 14. We all know prohibition in discrimination on ground of race, religion, the sex, place of birth. Article 15. This is right. Equal opportunity in the method of public employment, Article 16, and abolition of untouchability, 17, all are correctly matched. Now the option is to be carefully watched. ঠিক আছে, ইয়াতে আপুনি all of these মাৰি দিলে কি হৈ যাব? All are not correctly matched হৈ যাব। গতিকে this should be none of the above. None of the above are not correctly matched. That means all of the above are correctly matched. Okay, so be very careful. Okay, so civic equality kotha jodi koy, following articles have ensured it: equality before law, prohibition in discrimination on the grounds of race, religion, caste, creed etc., place of birth, equal opportunity in the matters of public employment, abolition of untouchability and abolition of titles. So ei gote khinie civic equality kotha represent kore, thik ase? Next, which of the following case Supreme Court said that the preamble shows general purposes behind several provisions in the constitution and does a key to the minds of makers in the constitution? Thik ase? Okay, so this case is Beruwari Union case. Beruwari Union case, Golaknath case, then amar Keshavananda Bharati case, Minerva Mills case. Okay, so these cases are very important. আৰু এডিশনালি আপোনালোকৰ এল চন্দ্ৰ কুমাৰ কেছ। সো আপোনালোকে আই হোপ এখিনি আপোনালোকে পঢ়িছে। ওকে, ট্ৰিবিউনেলছৰ ক্ষেত্ৰত কিছুমান কেছ আহিছে নেকি, এনেকুৱা ধৰণৰ কেছবিলাক আপোনালোকে পঢ়িব। বেৰুৱাৰী ইউনিয়ন কেছত কি হৈছিলে? সুপ্ৰিম কোৰ্টে কৈছিলে কি preamble shows general purposes behind the several provisions in the constitution, so it is a key to the minds of the makers of the constitution. Okay, very important. Despite this recognition of significance in preamble, the Supreme Court কিন্তু কি কৰিছিলে কেছটো? Preamble is not a part of the Indian constitution বুলি ঘোষণা কৰিছিলে। Now there are certain cases where you will find preamble is not a part of Indian constitution. Which are the cases? Please list it down. In which cases it was said that preamble is a basic structure of Indian constitution আৰু it is a part of Indian constitution. So সেই বস্তুখিনি আপোনালোকে categorize কৰিছে বুলি মই ভাবো। Definitely it will help you. Which of the following major factors can be taken into account in any scheme and organization of state? So 3 member এখন committee constitute কৰা হৈছিলে State Recognition Commission বুলি under the chairman of Fazal Ali. So এই কমিশন খনৰ এটা দায়িত্ব দিয়া গৈছিলে কি you please identify some factors যেতিয়া recognition of state আমি কৰিম বা যেতিয়া state এখন recognize কৰিম, okay, আৰু তাৰ any scheme যদি সেই recognition of scheme or এই recognition of state মানে state এখন recognition কৰি পেলাই apply যিবিলাক schemes and all যদি আমি apply কৰো, so কি কি কথাত গুৰুত্ব দিব লাগে বা কোন কোন factors ৰ ওপৰত ডিপেন্ড কৰে যে any scheme that to be implemented in a particular state after its recognition. So that has been given by the Fazal Ali Commission. Okay, so preservation and strengthening of the unity and security of the country, linguistic and cultural homogeneity. So these are the factors to be considered. Okay, financial, economic and administrative consideration. Religious belief cannot be correct. So option 1, 2 and 3 correct. So there are actually 4 factors. Last factor was planning, promotion of the welfare of the people in the state as well as of the nation. Okay. Next question, which of the following are not correctly matched? Assam Alteration of Boundaries Act of 1951 yata ki koise provisions to alter the boundaries of the state of Assam by ceding a strip of territory comprised in that state to Bangladesh. So this cannot be Bangladesh, this should be Bhutan. Okay. And Andhra State Act of 1953 formed the first linguistic state known as the state of Andhra by taking out of the Telugu speaking areas from the state of Madras. So this option is correct, by the way. So amak ki kobo dise, which of the following statement is not correct? Option 1, that is mentioned in option A. Okay. Explanation. Assam Alteration of Boundaries Act of 1951, it altered the boundaries of the state of Assam by ceding a strip of territory comprised in that of the state to Bhutan, not Bangladesh. Please remember this point. Next question is question number 23. Question number 23 ki bodi se, which of the following foreign nationals are eligible for registration as OCI ba overseas citizen of India card holder? Okay, so yate mon koribo OCI NRI eligibility criteria, কি প্ৰিভিলেজৰ কাৰণে এলিজিবল, কি প্ৰিভিলেজৰ কাৰণে নট এলিজিবল, সেই কথাখিনি আপোনালোকে ভালকে পঢ়িব লাগিব। ঠিক আছে, সেইখিনি আপোনালোকে অলপ ফ্যাকচুৱেল ইন নেচাৰ হয়, বাট আই হোপ আপোনালোকে ৰিভাইজ কৰিছে। এটা কি কৈছে, ওচিআই হিচাপে তেতিয়াহে তেওঁ চিহ্নিত হ'ব যেতিয়া হু ওয়াজ এ ইণ্ডিয়ান সিটিজেন অফ ইণ্ডিয়া এট দ্য টাইম অৰ এট এনি টাইম আফটাৰ কমেন্সমেন্ট অফ কনস্টিটিউশন 26/1/1950। ঠিক আছে, হু ওয়াজ এলিজিবল টু বিকাম এ সিটিজেন অফ ইণ্ডিয়া এজ অন 26/1/1950, this is also correct. Who belong to a territory that become a part of India after 15/8/1950. It cannot be 1950, it should be 1947. Okay, so ebilak horu horu kotha apnaloke statement bur bhalke poiba. Who is a child or a grandchild or great grandchild of such citizen? So option 1, 2 and 4 are correct here. This option is not correct. Okay, if you see here, there are certain eligibility criteria such as এজন citizen হব কারণে at any time এই মানুহজন citizen who was a citizen of India at any time or at any time after the commencement of the constitution, that is 26/1/1950, who was eligible to become a citizen of India as on 26/1/1950, who belong to a territory that became a part of India after 15/8/1947. Okay, aro who is a child or a great, etu jontu bhul asile amar 1950 dia asile option, right? Who is a child or great grandchild or grandchild of such citizen, this is correct also. Who is a minor child of such person mentioned in above cases. Who is a minor child or whose both parents are citizen of India or one of the parents is citizen of India. Spouse of foreign citizen of India and spouse of foreign origin of overseas citizen of India card holder registered under Citizenship Act 1955 and whose marriage has been registered aru kiman bosorer kane subsisted hoi thakibo lagibo for a period not less than 2 years immediately preceding for presentation of the application. Okay, so these are important points to be noted. So now question number 24, which of the following fundamental rights are incorrect? Okay, the right to property was deleted from the fundamental rights by 42nd Constitution Amendment Act, this is not correct. They are absolute but qualified, this is correct. 6 rights guaranteed under 19 can be suspended only when emergency is declared on the ground of armed rebellion, that is internal emergency. This is not correct, this is external emergency, war or external emergency khetrot hobo, this is not correct. Aru ki hoiche, the violated aggrieved person can directly go to the Supreme Court. Okay, so yat not correct jehetu hudise, incorrect jehetu hudise, then 1 and 3 are incorrect, but I can see this option is wrong because jodi etu correct holten titiya 2 and 4 correct holten. So please etu rectify kori lobo, that statement should be which of the following is or are is correct. Okay, not incorrect, this should be correct hobo laibo karon option 2 and 4 are correct here, 1 and 3 are not correct. Okay, so option 2 and 4 আৰু 2 and 4 should be correct. যদি incorrect দিলেহেঁতেন তেতিয়াহ'লে অপশ্যন কি হ'লহেঁতেন আৰ্টিকল statement 1 আৰু statement 3 that option নাই বুজিছেনে বুজি পাইছে গতিকে always be careful এটো দিউতে ভুল কৰিছে তো মই নোটিস হৈছে কাৰণে কৈ দিছো কথাটো explanation the right to property was deleted from the fundamental rights by 44th constitution amendment act 1978 আৰু এটো legal right under article 300A okay in part 12 of the constitution place কৰা গৈছিলে fundamental rights are not absolute আৰু but qualified state reasonable restriction ইয়াৰ ওপৰত প্লেস কৰিব পাৰে কিন্তু ইন যিকোনো ক্ষেত্ৰত যেতিয়া তেতিয়া ফান্ডামেন্টাল ৰাইটছৰ ওপৰত ৰেস্ট্ৰিকশন ডেফিনেটলি লগাব নোৱাৰে unless you take permission from courts they are defended and guaranteed by supreme court আৰু যদি aggrieved হয় কোনোবা পাৰ্সনাৰ যে মোৰ ফান্ডামেন্টাল ৰাইট ভায়োলেট হৈছে then they can directly move to the supreme court directly go to the supreme court ঠিক আছে six fundamental rights guaranteed under article 19 can be suspended on the grounds of war and external aggression external emergency not under the ground of armed rebellion or internal emergency ঠিক আছে next we will go to the question number 25 fundamental rights আৰু এফালে related article match কৰিব দিছে protection which of the following are not correctly matched কৰিছে okay protection in respect of conviction of offenses article 20 important আৰু শুদ্ধ হৈছে article 20 article 21 এটোটা ভালকে চাব আৰু fundamental rightৰ ক্ষেত্ৰত article 358 আৰু article 359 okay article 358 or article 359 you will have to know ঠিক আছে in case of emergency also আৰু তাতে fundamental right ৰ লগত কি কি হয় এই বস্তুকেইটা আপোনালোকে যদি জানিব বিচাৰিছে then you will have to know these two article or their inherited meanings okay then prohibition of traffic in human beings and forced labor article 23 this is correct freedom from payment of taxes for promotion of any religion this is not correct protection of language script and culture of minorities under article 30 this is not correct so 3 and 4 are not correctly matched okay okay freedom of payment from taxes for promotion of any religion comes under article 27 28 boli dia goise most probably and protection of language script and culture of minorities it is article 29 not 30 next question number 26 which of the following cases supreme court of india held that the protection under article 21 is available only against arbitrary executive action not from arbitrary legislative action very important judgment it is in gopalan case 1950 so if you see the explanation this was a famous gopalan case okay supreme court a narrow interpretation of article 21 dise yes it held that protection under article 21 is available only against arbitrary executive action not from arbitrary legislative action okay tar mane ki koise the state can deprive the right of life and personal liberty of a person based on a law okay if some law permits in that case they can restrict it okay this is because expression procedure established by law in article 21 which is different from the expression due process of law which is contained in the American Constitution so there is a difference also next 27 which of the following are correct regarding right to education article 21 A declares that states shall provide free and compulsory education to the children of the age of 6 to 14 years okay ketiaba eto 0 to 6 years boli di dibo sabo gotike eto monot rakhibo so this statement is correct here this provision was added by 46th constitutional amendment act is it correct is it 46 it was added by 86th constitutional amendment act of 2002 okay Aru, the government described this step as a second revolution in the chapter of citizens' right. Okay, it is just made fundamental rights under Article 21A. Before it was listed in DPSP. Which article? Please let me know in the comment box. Which of the following, with reference to the Central Waqf Council, consider the following statement, and which of the following statements are correct? It is a statutory body under the administrative control of Union Ministry of Minority Affairs. It acts as a national level apex authority, apex advisory body to the central government. So here both A and B statements are correct. ইয়াত অপশনটো মাৰ্ক কৰা হোৱা নাই সো হিয়াৰ both A and B statement are correct ঠিক আছে statement are correct here okay option C I am marking it now okay option C is correct ठीक है next 29 consider the following statements regarding National Commission for Women National Commission for SCs National Commission for BCs National Commission for STs National Commission for Women okay আৰু child rights or karne বা National Human Rights Commission এই গুটে কমিশন কেটা কথা আপোনালোকে চাব লাগিব composition election appointment এনেকে হয় এই গুটেখিনি চাব nomination হয় না election process হয় না কি হয় this was established under National Commission of Women Act 1990 so kuntu correct hodise this is correct it functions under Ministry of Social Justice and Empowerment this is not correct ঠিক আছে family welfare ne social justice ministry keta janibo lagibo NCW has the power to enforce legal action and directly penalize the violators of the women's right is it correct no so option 1 is correct only National Commission for Women was an autonomous statutory body to protect and promote women's right in India formed under National Commissions for Women Act 1990 functions under Ministry of Women and Child Development okay it does not have direct penalizing power but it can recommend actions to the authorities so nature of this body was what enake question ahibo pare okay with reference to the Comptroller and Auditor General CAG kotha hodise consider the following statements CAG is appointed by the President of India and holds office for terms of 6 years or 65 years whichever is earlier so right statement hodise the CAG can be removed from the office in the same manner as Supreme Court just through a resolution passed by both House of the Parliament with simple majority no this is not correct CAG submits 3 audit reports to the Prime Minister no he submits the report to the President of India okay so 1 only is correct here why 2 and 3 are not correct CAG can be removed from the office in the same manner as Supreme Court of Judge eto thike ase but it has special majority lagibo number 1 number 2 CAG audit report keta kakak dia President of India report keta ki thake audit report of appropriation account 3 type of very important reports you should keep in mind audit reports on finance account and audit reports of public undertaking okay aru he report kini parliament ot place kora jay through Public Accounts Committee so these are very important points you should take a note on that 31 with reference to the Public Accounts Committee of Indian Parliament consider the following statement it is an constitutional body so kun keta correct hodise not constitutional body the chairperson of the committee is always from the ruling party it maximum khetrot hoi jay kintu this is not written ঠিক আছে this is not correct it examines the audit reports of the Comptroller and Auditor General of India this is correct so option 3 is correct only 1 and 2 are not correct so it is a part just a minute okay it is a parliamentary committee not a constitutional body okay it is constituted under rules of procedure and conduct of business in Lok Sabha chairperson appointed by Speaker of the Lok Sabha and usually from the opposition party not from the ruling party okay usually these are appointed from opposition party not from the ruling party and who appoints Speaker of Lok Sabha okay next question we will see question number 32 in-house inquiry into the conduct of judges is limited to the financial arbitrations it requires parliamentary approval under article 124 of Indian Constitution which of the following statement is correct if you see first statement is correct but second statement is not correct here okay so prothomon ma option to koilo first statement is not correct and second statement is also not correct first is also not correct and second is also not correct here mane option D is correct here okay in-house inquiry kotha ki koise ate the need for a in-house inquiry mechanism arose in okay 1995 following an allegation of financial impropriety against Bombay High Court Chief Justice A.M. Bhattacharjee the process was refined in 2014, after a sexual harassment complaint led to the establishment of 7-step inquiry framework. So this statement, that's why this was not correct. Statement 2 ki hoga not correct. In-house inquiry is an internal mechanism aimed at, it is an internal mechanism, okay, aimed at addressing the conduct of inconsistent with judicial values, okay, addressing conduct inconsistent with judicial values. Aru this is not similar to the impeachment process which requires parliamentary approval. Parliamentary approval under Article 124 of the Constitution. Okay. So next question we will go. Question number 32. Central Bureau CBI report question is which of the following statements are correct? It was established in 1963 on recommendation of Santhanam Committee. This is right. The CBI headed by director for a tenure of 5 years, appointed by central government on recommendation of 3-member appointment committee. This is not correct. Option 1 is correct. So appointment of CBI directors is also important. Here not correct. CBI is headed by a director that tenure to only 2 years hoy, or appointment by central government on recommendation of 3-member appointments committee. So this cannot be 5 years. Okay, this should be 2 years. Next, 33. Which of the following is not a characteristics of money bill under 110 of Indian Constitution? It can only be not a characteristics will be said. So remaining statements will be correct. Only one statement will be false. It can only be introduced in Lok Sabha. This is correct. It requires president's recommendation for introduction. Okay, so president's recommendation will be placed for it. Rajya Sabha can amend it. No, it doesn't have any power to amend it. It deals exclusively with matters like imposition of taxes and withdrawal from the consolidated fund of India. This is right also. So option C should be not correct here. Okay. Next, money bill can only be introduced in Lok Sabha. Article 109(1) section explicitly state that money bill shall not be introduced in Rajya Sabha. Cannot amend also. Okay, just it can suggest amendments, but this is on Lok Sabha whether they will consider it or not. Lok Sabha has the final say. They cannot make any changes on the bill. Okay, on the money bill. It was not introduced also. So Panchayati Raj system or বিষয়ে খুদিছে কোন কেটা statement correct? Balwant Rai Mehta committee report recommended the formation of a democratic system of government at the grassroots level. This is correct. Balwant Rai Mehta committee কথা যদি আপুনি পঢ়া নাই তেতিয়ালে পঞ্চায়তী ৰাজ সিস্টেমটো আপুনি ভালকে বুজিয়ে নাপাব. ওকে, সো 3-tier system কেনেকে ভিলেজ লেভেলত কি থাকে, ইন্টাৰমিডিয়েট লেভেলত কি থাকে, হয়নে, আৰু জিলা লেভেলত কি থাকে, আৰু in certain cases কি আছে, we can skip the intermediate level. So what condition needs to fulfill to skip one level in the middle level? Okay, population related etu apnaloke pohi lobo, thik ase. In 1993 by 73rd Constitution Amendment Act, the parliamentary system come to be implemented in the rural areas. So yate confuse hobo pare, this act was passed in 1992 but it came into existence in 1993. That's why this statement is considered to be correct. Okay, so both statement is correct here. Okay, so 3 levels jenake moi koisilu. Gram Panchayat at the village level, block Panchayat intermediate level, aru Jila Panchayat at district level. ঠিক আছে, 3-tier Panchayat. Aru chairman keneke appoint kore in Gram Panchayat, state legislature by law, block and Jila Panchayat keneke kore among themselves chairman hoy niki. So ei gote bostu khini apnaloke sai lobo ebar. With reference to the office of the governor, consider the following statements. The office of the governor is defined in Article 153 to 162 of Indian Constitution. This is right. He can continue to be a member of parliament or state legislature. This is a very easy question. This is not correct. Okay, option 1 is correct only. Okay, so eligibility is sai citizen of India and has completed the age of 35 years minimum hobo lagibo. Parliament or state legislature member hobo nwaribo. Shall not hold any other office of profit for being a governor. Next, 36. With reference to the Central Information Commission, it is a statutory body constituted under Right to Information Act 2005. This is right. Okay, it consists of Chief Information Commissioner and not more than 5 Information Commissioner. It should be not more than 10. Okay, here option 1 is correct only. Okay, it consists of Chief Information Commissioner and not more than 10 other information commissioners. They are appointed by President of India. Our headquarters kota ase New Delhi ase. We'll move to the question number 37. Review petition kotha hudise. So review petition and election petition আপোনালোকে দুইটাৰ মাজত ডিস্টিংগুইশ কৰি ল'ব ইলেকশন পিটিশন কেতিয়া ইন্ট্ৰোডিউস কৰিব পাৰি হেতু কেতিয়াবা আহিব পাৰে বা ৰিভিউ পিটিশনৰ ক্ষেত্ৰত কোৱেশ্চন আহিব পাৰে ৰিভিউ পিটিশন ইন সুপ্ৰিম কোৰ্ট অফ ইণ্ডিয়া কনসিডাৰ দ্য ফলোইং স্টেটমেন্ট দ্য কনস্টিটিউশন অফ ইণ্ডিয়া গ্ৰান্টস সুপ্ৰিম কোৰ্ট দ্য পাৱাৰ টু review its own judgment or orders ঠিক আছে this is correct anyone aggrieved by a ruling can file a review petition not just by the parties to the case তাৰ মানে যি কোনো লোক তেওঁ যদি কেছটো পাৰ্টিও নহয় সেই ৰুলিংটোৰ দ্বাৰা যদি প্ৰভাৱিত হৈছে বা এফেক্ট হৈছে they can also file review petition okay next review petitions are always heard by the same constitutional bench that delivered the original judgment yes 1 2 and 3 both are correct this etu yala ahi bola isle but paste to mara nidile aru thik ase so option C is correct here so if you see here review petition in the Supreme Court of India is filed under article 137 of Indian Constitution aru this power is however subjected to the rules made by the Supreme Court under article 145 as well as the provisions of any law that is enacted by the Parliament of India anyone ji kono byakti june Supreme Court or ruler dara effect hoy except the party to the cases may apply the review petition okay they are always heard by the same bench that delivered the original judgment jikhon bench e disile aru jar against review petition file kora hoise that are being heard by them only thik ase if the judges on the original bench have retired the chief justice will use his discretion to replace them jodi এই বেঞ্চত বহা কোনো লোকৰ ৰিটায়াৰমেন্ট হৈ গল how can he again entertain that review petition in that case chief justice of India has a special discretionary power that he can replace that person by appointing another judges in that respective bench which are entertaining that review petition okay next we will move to the question number 37 consider the following statements first administrative reform commission has recommended two-tier machinery consisting of Lokpal and Lokayuktas in India that is correct jurisdiction of Lokpal currently covers any society or trust or body that receives foreign contribution above 10 lakhs yes both 1 and 2 options are correct okay if jodi explanation sai ARC the first administrative reform commission 1966 e ki korisile two tier machinery Lokpal aru Lokayukta public or grievance address kora karone establish koribo karone koisile aru Lokpalar jitu jurisdiction ase it includes all categories of public servants within and outside India okay including prime minister except on allegations of corruption relating to international relation security public order atomic energy and space ekita mona rakhibo which of the following are outside the purview of jurisdiction of Lokpal thik ase it covers any society or trust or body that receives foreign contribution above 10 lakhs or uporot jodi foreign regulation ba foreign donations pai ketu kiman authentic hoy thik ase etur uportu Lokpale bibesona karibo pare ba teloke sali jari sabo pare thik ase which of the following statements regarding private member bill is correct it can be introduced by both ruling and opposition MPs definitely rejection of such bill affects the stability of the government no never it requires 1 month notice before the introduction this is right because parliament is a very busy machinery right so if any private member wants to place one bill of his own then he will have to give one month notice before the introduction okay debate on such bills is generally scheduled on Mondays this is not right this generally this is in Fridays okay so 1 and 3 only are correct 2 and 4 are not correct here okay so a rejection of private member bill doesn't imply lack of confidence in government does not affect it okay aru debate on such bill generally scheduled on Fridays with reference to the national anthem consider the following statements showing respect to the national anthem incorrect hoise showing respect to the national anthem is a fundamental duty this is correct it was first sung in 1929 at the Lahore session of Indian National Congress is it right it is not okay so please don't forget it is Calcutta session but this one Calcutta session not prothom it was sung thik ase So under National Honor 1971, anyone who intentionally obstruct singing of the national anthem, তাৰ কাৰণে penalty ব্যৱস্থা আছে, he will face a sentence up to 3 years or a fine or both. Okay, আৰু showing respect to our national anthem is a fundamental duty under Article 51A. ঠিক আছে? Next, oath and affirmation of কথা কৈছে member of parliament. So oath of affirmation কি হয়, oath of secrecy কি হয়? I hope the conception is clear with you. So ইয়াতে কি দিছে? Oath and affirmation of member of parliament. Oath and affirmation can be taken only in 22 languages that are specified in the Indian Constitution. What about English? This statement is wrong. If an MP fails to take an oath or affirmation within prescribed time, their seat may be declared vacant. So here, which of the following statements? This is correct. Two only. So Article 99 ki koise, every member of either house of the parliament shall, before taking their seat, they have to take oath or affirmation, which is mentioned to the 3rd schedule of the Indian Constitution. President, governor or vice president or oath or affirmation kotha kot mention kora ase, muk comment box ot janabo. Thik ase? Oath and affirmation not only taken in other languages, 22 languages, but English or loleo permission ase. Thik ase? 41. Deputy Speaker related question is, according to the Indian Constitution, Deputy Speaker of Lok Sabha must be from the opposition party only. No, there was no Deputy Speaker for entire duration of 17 Lok Sabha. This was also in news. So that's why recently our Deputy Speaker আজি প্রায় 3 বা 4 দিন আগত newspaper আহিছে. So Deputy Speaker related এটা article in Assam Tribune also. I think it's in page 2 or I think in the left side page. তলত আহিছে আপোনালোকে চাব পাৰিব. 2 or I think in 6 or 9th page. Okay. Explanation. He is elected by the Lok Sabha itself among its members. Election of Deputy Speaker is governed by Rule 8 of Rules of Procedure of Conduct of Business in Lok Sabha. Usually chosen from the ruling party or ruling alliance. যিজন স্পিকাৰৰ কথা কৈছে, আৰু Deputy Speaker is selected from the opposition party or opposition alliance. However, there have been exceptions. গতিকে mandatory নহয়, exceptions আছে. যে first আৰু কি কৈছে, first four Deputy Speakers from 1952 and 1969 were from ruling party. ঠিক আছে? There were no Deputy Speaker for entire duration from 17 Lok Sabha, that is 2019 or 2024 leke. Now, in absence of Speaker, who can be Deputy Speaker? Kun hobo Deputy Speaker kune nirnoy kore? Who decides that? But who appoints? But okay. Aru in case of bole Speaker absence ase, Deputy Speaker absence ase, ejon he house ore byaktik jetia proceeding cholabo dia hoy he house tur teo kune appoint kore? Prime Minister, Vice President, President, who? He topic eta apnaloke bhalke sai lobo. With reference to the Lok Sabha Speaker, ebar Speaker kotha koisu, consider the following statement. According to the Indian Constitution, the Speaker of Lok Sabha must be from the ruling party only. Okay. In the absence of the Speaker, the Deputy Speaker discharges his or her functions. This is not correct. Must be from ruling party boli kono kotha nai. Okay. In the absence of the Speaker, Deputy Speaker discharges his or her functions. This is by convention. Okay. Article 93 of Indian Constitution provides for election of both Speaker and Deputy Speakers. Generally, a member belonging to the ruling party is considered to be elected as Speaker. However, it is not a constitutional provisions. Okay. Constitutional provisions nahi kintu. To the Committee of Privileges, which of the following consider the following statements? Which of the above statements are not correct? Okay. It consists of 15 members nominated by Chairman of Rajya Sabha. This is correct. Okay. The Chairman of the committee is appointed by the Speaker of Lok Sabha. This is not correct. Parliamentary privileges are special rights granted by the members of the granted only to the members of Rajya Sabha. This is also not right. So not correct. 2 and 3 are not correct here. So we'll discuss about it. Statement 2 ki hoga not correct. The Chairman of the Committee of Privileges in the Rajya Sabha is appointed by Chairman of Rajya Sabha, not the Speaker of Lok Sabha. ठीक है? Statement 3 ki hoga incorrect. Parliamentary privileges are special rights and immunities granted to both houses of the parliament, that is Lok Sabha and Rajya Sabha. Which of the following statement about joint committee of parliament is JPC kotha koise? Not correct. JPC is a permanent committee of parliament. A members of JPC are drawn from the only from the Lok Sabha. This is all right. A JPC is constituted for specific purpose and so now next question is question number 44. Which of the following statement about JPC is correct? Kuntu correct hodise. A JPC is a permanent committee of parliament. No, this is not correct. These are members are drawn only from Lok Sabha. This is also not correct. JPC is constituted for specific purposes and dissolved after completing its task. Yes, definitely correct. Recommendation of JPC are binding on the government. No, this is advisory in nature. This is advisory in nature. Okay. Next, JPC is formed by parliament for a specific purpose such as detailed scrutiny of subjects or a bill. It includes both from Rajya Sabha and Lok Sabha members representing ruling and opposition parties. Okay. It is dissolved once the task is completed. To set up a motion to be passed by one house of the parliament and agreed to by other. Okay. It is set up koribo karone JPC set up koribo karone motion eta pass koribo lagibo. Eta house pass koribo lagibo parliament aru anata house ki koribo lagibo accept koribo lagibo. Members of the JPC are chosen by the parliament and its size may be varied. Recommendation made by JPC are not binding on the government but have persuasive value, that is persuade koribo karone try kore and advisory in nature. The government must report back the actions taken behind the JPC's recommendation. Teolokor recommendation opor bhitti kori government ki action lole sei kotha to janabo lagibo. Okay. Next we will move to the question number 45 with reference to the Competition Commission of India. Which of the following statement is or are correct? CCI kora hodise commission comprised of chairperson, a chairperson and between 2 to 6 additional members. This is correct. It is a non-statutory body under Ministry of Corporate Affairs. This is not correct. Okay, so option 1 is correct here. So it is a statutory body. Government of India under Competition Act of 2002 under established kora hoisil. Jo act or under body established hole definitely statutory body hobo. Aru same eketa correct ase under Ministry of Corporate Affairs if function kore. With reference to the National Investigation Agency NIA, consider the following statements. Aru kun keta correct hodise. It is the primary counter-terrorist task force in India and functions under Central Counter-Terrorism Law Enforcement Agency. This is right. It investigates the crimes committed outside India. Okay, if they involve Indian citizens or affect Indian interests. This is applicable after the NIA Amendment Act. Okay, sir. But both of these options were correct. So option C is correct. Okay, sir. The National Investigation Agency, the primary counter-terrorist task force. Okay, established in 2009 after enactment of National Investigation Agency Act 2008. Aru NIA has the authority to investigate the offences across India. NIA Amendment Act 2019 ki kore NIA is empowered to now investigate the crimes committed outside India also if they involve Indian citizens or affect India's interest. Okay, sir. Next we will go to the question number 47. With reference to the removal of Vice President of India, consider the following statement. The resolution cannot be moved unless a notice of at least 14 days has been provided. This is right. A resolution can be introduced at any house of the parliament. No, this resolution has to be passed in Rajya Sabha. Okay, so option 1 is correct only. ठीक है sir. Process to Silog, a resolution for removal may be introduced in Rajya Sabha only, which requires majority not less than 50% of the members present plus one on the day of voting. If approved, the resolution moves to the Lok Sabha where it must be passed by a majority to take this effect. Once both houses passes the resolution, Vice President is removed from this office. Impeachment of President, removal of Vice President, removal of High Court and Supreme Court judges are very important. What are the condition for removal of Vice President? Kiba condition mention ase niki constitutional? Okay, so hetu eta question keteba ahe. With reference to the arbitration and conciliation, okay, these are method for alternative dispute tribunal. So these methods are used there. Okay, so arbitration and conciliation, consider the following statements. Arbitration is a form of Alternative dispute resolution, which is binding in nature. Yes. Conciliation is a voluntary process where neutral third party helps the disputing parties to reach a mutually acceptable agreement or settlement. So all these two statements are correct. Methods for ARC and তেওঁলোকৰ যিবিলাক ইনষ্টিটিউচন আছে লোক আদালত ফেমিলি কোৰ্ট বা গ্ৰাম ন্যায়ালয় এইখিনি ভালকে পঢ়িব গ্ৰাম ন্যায়ালয়ৰ গ্ৰাম ন্যায়াধিকাৰী হ'ব কাৰণে তেওঁ কি এলিজিবিলিটি ক্ৰাইটেৰিয়া আছে এটো আপোনালোকে এবাৰ ভালকে চাই লব ঠিক আছে and whether their advices are binding in nature, that is also important thing. Plus jurisdiction of these three bodies, moi jonketa bodies er kotha kolu family court e hok gram nyayalay hok so heketa jurisdiction to sai lobo mane teloke civil court mane cases try koribo pare ne criminal cases try koribo pare eto apnaloke ebar revise kori lobo thik ase next 49 number Constitution of India does not mention any procedure for which of the above statement are correct will you say appointment of Chief Justice of India this is correct seniority at apex court determined by age not by the date of judges not by the date a judge was appointed to the Supreme Court ulta kotha koi ase so option A is correct only kunjon judge senior hobo he khetrot keneke bibeshona kore seniority khetrot chao seniority at the apex court is determined not by the age but by the date of joining of the judge by appointment of the judge to the Supreme Court very important if two judges are elevated to the Supreme Court in the same day jodi ekelage ekedina dujon judge jodi uthe senior kunjon hobo the one who was sworn in first as a judge would trump over another so jijone prothom sworn in kore tekhet first hisabe senior hisabe consider hobo thik ase okay then another arota case ki hoy if both were sworn in the judge on the same day okay same date jodi hoy tetiale ki hobo aru eta criteria ki ase the one with more years of high court service ba high court experience should be given seniority thik ase so these are very important things please note it down 6th schedule er khetrot eta ki koise the governor has the authority to create autonomous district council and autonomous regional councils in the states of Assam, Meghalaya, Tripura and Mizoram. This is correct. They have the power to make the laws related to the forecast management, inheritance and social customs but do not have the authority to collect land revenue or impose taxes. This is not correct. Okay. So here option A is correct. My just explanation to koi do 6th schedule was adopted under article 224 of Indian Constitution ADC form koribo pare granted certain legislative judicial and administrative autonomy teoloko within the state die aim ki hoy allow tribal population to govern themselves it allows the governor to create ADCs and ARCs in the state currently this 6th schedule makes special provision for administration of tribal areas in northeastern state of Assam Tripura Mizoram and Meghalaya okay amar joto next question ase 51 number question ete ki hudise which of the following is are falls under socialist principle of DPSP now eta kotha apnaloke mon koribo DPSP is based on three important principles number one is socialist principle next Gandhian principle aru eta western liberal principle tar bhitor kun keta DPSP kun keta part ot pore ba jodi common enekwa dhoroner terms আছে জিবিলাক আমাৰ socialist plus Gandhian DPSP দুইটাতে পৰে সো তেনেকুৱা ধৰণৰ বিলাক আপোনালোকে আইডেন্টিফাই কৰি পেলাব লাগিব ঠিক আছে গতিকে socialist Gandhian আৰু western liberal DPSP কোন কেটা হয় ইন্ডিভিজুয়ালি হেকেটা আপোনালোকে মনত ৰাখাটো খুব জৰুৰী ঠিক আছে সো ইয়াতে দিছে কি which of the following বা which of the above statements are correct to নিৰ্বাচন কৰিব দিছে to promote equal justice and to provide free legal aid to the poor that is socialist principle this is right okay to make provisions for just and human condition of work and maternity relief this is also right aru ki dise to take steps to secure participation of workers in management of ইন্ডাষ্ট্ৰিজ ইন্ডাষ্ট্ৰিটো যাতে যিসকল ৱৰ্কাৰ আছে তেওঁলোকৰ ফ্ৰীডম অফ স্পীচ থাকে তেওঁলোকে যাতে গৈ পেলাই তাতে যিকোনো ধৰণৰ প্ল্যান আৰু পলিচিজ যিবিলাক ধৰক ইন্ডাষ্ট্ৰি এটা সাপোজ এক্সপানশন কৰিব বা তেওঁলোকৰ কিছু বস্তু ধৰক এটা ঠাইলে শিফট কৰিব সো তাৰ কাৰণে আমাৰ যিসকল ইন্ডাষ্ট্ৰিয়েল ৱৰ্কাৰ্ছ আছে তেওঁলোকৰ যাতে কিছু মত ল'ব লাগে তেওঁলোকৰ পৰা কিছু সাজেশনস ল'ব লাগে হেতুকো এনেবল কৰিব কাৰণে কি কৰিছে this DPSP has been inserted under socialist principle ঠিক আছে আৰু কি দিছে to secure for all citizens a uniform civil code throughout the country so this is not correct 1 2 3 are correct this is under western liberal principle okay so to secure all the citizen a uniform civil code throughout the country liberal intellectual principle of ভিতৰত পৰে okay so next question আমি 52 number question হলে যাম which of the following provision in the constitution can be amended by simple majority of the two houses of the parliament so কেটামান কথা মনত ৰাখিব under 368 আমি দুটা টাইপৰ স্পেশাল মেজৰিটি পাইছিলো প্লাস কিছুমান ইয়াতে কি আছিল আপোনাৰ 2/3 members must be present and voting আৰু এটো half of the 2/3 special majority plus হ'ব লাগিব plus half of the ratification of the state special majority কথা কৈ আছো ইয়াতে তাৰ বাহিৰেও under 368 article excluded যোন কেটা simple majority তাৰ আন্ডাৰত কি কি provisions আছে তাৰ ভিতৰত which of the above are correct এই কোৱেশ্চনটো সুধিছে so এতিয়া চাব admission or establishment of new states okay so this is correct power of parliament to amend the constitution and its procedure rules rules of procedure in parliament so this cannot be correct okay so etu ami simple majority pass koribo nuaru delimitation of constituencies this is right abolition or creation of legislative council in the state this is also right so here 1 3 and 4 are correct okay so why number 2 is not correct because this comes under the power of parliament to amend the constitution and its procedure rules of procedure in the parliament this requires special majorities of the parliament plus with the consent of half of the state legislature by a simple majority so consent of half of the state legislature is also required in this purpose okay so yata ki koise special majority plus half of the ratification of the state is also required ঠিক আছে next which of the following provisions are federal features of Indian constitution so mu comment box ot janabo federal features to amar constitution ot por pora adopt kora hoisile okay so division of powers between national and regional government this is right independent judiciary bicameral legislature written constitution so if you see carefully all of them are correctly placed under federal features so option 4 is correct here okay next we will okay so moi alop explanation di disu federal features or apnalokor monot thaki jabo so dual government that is national government and regional government national mane union government or koise aru regional respective state governments bilakor kotha koise okay division of power between union government and all the other governments that are being existed in the states etu eta hoy independent judiciary bicameral legislature ki ase upper house and lower house in case of parliament apnaloke ki thake lok sabha and rajya sabha thake hoine aru state in case of states ki thake apnaloke sabo kisuman bicameral legislature thaka state ase jeneke mane ki hoy apnar tate ki thake amar yate ki ase legislative assembly ase aru kisuman state ase tat jot ki ase legislative council ase now apnaloke mok comment box ot aru eta bostu janabo কেখন স্টেট আছে ইন্ডিয়াত যত লেজিসলেটিভ কাউন্সিল আছে ওকে হেতু মোক জনাবো আৰু সেই স্টেট কেখন কি হয় ওকে সো নেক্সট রিটেন কনস্টিটিউশন রিজিড কনস্টিটিউশন supremacy of constitution all these are the features of federal features of our Indian constitution okay next we will move to the question number 54 okay yate ki hodise which of the following ba which of the above statements are correct hodise there is correct hodise okay there is no limit to the power of parliament to amend the constitution this cannot be correct only the president can decide whether any matter forms a part of the basic structure of constitution this never be correct okay so yate etao jehetu correct nohoy gotike neither 1 nor 2 is correct here option D is correct Okay, explanation sabo. If you have studied properly about Kesavananda Bharati case, this is a very important case. This is a landmark judgment has been given by Honorable Supreme Court. Okay, Supreme Court ki koisile? In this case, it ruled that there is a basic structure of constitution and nobody, not even the parliament through an amendment, can violate the basic structure of constitution. Jodi amar basic structure jar upor mane if you allow some institution like parliament to change this basic structure of constitution by an amendment, then amar gutei সংবিধানিক juntu ground hoy juntu bheti hoy hetu ki hoy jabo, that will not be secure. That's why certain parts that were classified as basic structure of constitution and Supreme Court provided the protection. It provided the protection in Kesavananda Bharati case that nobody can amend, even the parliament can violate the basic structure of constitution. Okay, the court two more things aru duta judgment asile yate. Okay, first it said that right to property was not a part of basic structure and therefore could not be suitably abridged but taken away. Thik ase. Secondly, court ki koisile reserve to itself the right to decide whether various matters are part of the basic structure of constitution. Now this is a very important judgment. The responsibility or the authority to declare something that it will fall under the basic structure of constitution will lie in the hands of Supreme Court. Why? Because it is the guardian of our democracy. Okay, so this is one of the important judgment. President or hatot nai, Supreme Court will decide. Okay, but the court will decide. Okay, which of the following directive principle was added by 42nd? So which of the following were? It should be where. Okay, added by 42nd Constitutional Amendment Act to secure opportunities for healthy development of children. This is right. To promote equal justice and to provide free legal aid to the poor. So opportunities for healthy development of children plus justice, equal justice. Okay, DPSP ineo ki koy social and economic justice upor focus kore, right? So ki koise promote equal justice and to provide free legal aid to poor. So in case of matter of judiciary also, how it has been implemented in judicial system to provide free legal aid to poor? Can you name one institution by provision? So jodi apnaloke nalsa kotha pohise, okay, ba apnaloke district legal service authority kotha pohise, then this fact will come into your mind. Okay, so next ki koise to minimize inequalities in income, status, facilities and opportunities. This is not added by 42nd Constitution. To promote the development of Hindi language, this is also not added by 42nd Constitution Amendment Act. So 1 and 2 are correct only. Okay, so to minimize inequalities in income, status, facilities, etc., it has been added by 44th Constitution Amendment Act 1978. Ito monot rakhibo. Thik ase? Aru development of Hindi language, this should be Article 351 of Indian Constitution. Aru Article 351 pohar logote apnaluke also remember Article 351A. Okay, etu ki hoy muk comment box at apnaluke janabo, khub important. Next, 56. Which of the following commissions committee accepted the language as the criteria of recognition of state? Dhar Commission? No. JVP committee? No. Fazal Ali Commission? Ami already pohisilwe. Sarita criteria di disile Fazal Ali Commission previous question. So jodi simple question ahe eneke ahibo pare. So here option C is correct. So ami Dhar Commission aru JVP committee olopman sai lo. So they actually rejected language as the basis of recognition of state. Okay, this is very important. You can note it down. So which are the two committees that have rejected language as the basis for recognition of states? Okay, aru Fazal Ali Commission le ki korisile broadly accepted the language as the criterion for recognition of states. However, it rejected one language state policy. Okay, ঠিক আছে? So এইকেইটা কথা important, that's why মই ইয়াতে মেনশন কৰি দিছো 57 parliament's power to recognize the states. Okay, which of the following statement with regard to the parliament's power to the recognize of the states are বা is correct? ঠিক আছে, any bill contemplating to the changes can be introduced in the parliament only with the prior recommendation of the president. Okay, this is right, this is right. Under Article 3, Parliament's power to diminish the areas of a state includes the power to cede Indian territory to a foreign state. This is not correct. Any bill aiming to recognize states shall be passed in Parliament by a special majority. This is also not right. That's why I am telling you the Parliament's power regarding provisions of Article মানে যোনটো 368 or under special majority provisions আৰু simple majority provisions খিনি regarding bill also আপোনালোকে কি কৰিব লাগিব মনত ৰাখিব লাগিব okay so statement 2 is not correct কিহৰ কাৰণে article 3 of Indian constitution the parliament has the power to diminish areas of the state does not include the power to cede the Indian territory to a foreign state okay foreign state ok je ami amar অংশ cede কৰি পেলাই দি দিম that doesn't come under this one article 3 Indian territory can be ceded to a foreign state only by amending the constitution under article 368 okay so can you tell me about one act through which we ceded certain parts to Bhutan okay comment box janabo statement 3 is not correct any bill aiming to recognize the state shall be passed in the parliament by simple majority only okay not special majority. Next we will go to the question number 58. So we are asking about president's rule in a state. ठीक है which of the following situation can be considered as proper for imposition of president rule in the state? Maladministration of state. So আমাক কি সুধিব দিছে ইয়াতে can be considered তাৰ মানে true applicable in respect to president rule of the state. Okay, maladministration in the state. The government is deliberately acting against the constitution. This is right. A constitutional direction of the central government is disregarded by the state government. So these are the two most important facts. And whenever we have studied regarding president's rule, a rule duta apnalokor sobse prothomote likha ase if you have studied carefully. Okay. So option C is correct. Jot 2 and 3 provisions are correct here. Yet the imposition of president's rule in a state would be improper under following condition. What are the conditions which are considered that we are not properly implementing president's rule in a state? Okay. So imposition of president's rule in a state would be improper under the following conditions: where a ministry resigns or dismissed on losing majority support in the assembly, and the governor recommends about imposition of president's rule without probing the possibility of forming an other government. So ami eta government jetia ministry resign kore ba dismiss hoi jay governor ki hoy baki alternative party certain provisions are there, you have studied it okay ba sarkariya commissioner ro kisuman recommendation asile I hope you have studied it so hekhini fulfill nokorake jodi direct president's rule impose koribo karone die then that will not be valid. Where the governor makes his own assessment of the support of ministry in the assembly and recommends imposition of president's rule without allowing the ministry to prove it majority in the floor of, so floor test must be there. Okay, opportunity for floor test should be given. After that jodi no hoy then you can do certain provisions also. ठीक है sir. Where the ruling party is enjoying majority support in the assembly has suffered a massive defeat in the general election to the Lok Sabha as in 1977 and 1980, internal disturbances not amounting to the internal subversion ba physical breakdown jodi heblak nuhuake apuni declare kore that will be also considered means improper imposition ba maladministration in the state or allegations of corrupt against the ministry or stringent. Okay, so eketa khetrot jodi apuni president rule impose koribole recommend kore governor ba president rule jodi impose hoy that will be considered as improper imposition. Okay, then you will have to go to the judiciary aru ki ase state government is where the state government is not given prior warning to rectify itself except extreme emergency leading to the disastrous consequences. So you will have to warn the state also that union government is giving certain schemes to implement you, by union government has provided you certain things to implement, but you are not properly doing it for last 8 months or 6 months, you are not running it properly, you have to give warning. Okay, direct go pela president rule recommend kori pela imposition kori dibo nare. Where the power is used to sort out inter-party problems of the ruling party or for a purpose of extraneous or irrelevant one which has been conferred by the constitution. Now suppose ruling party bitor majot kiba kajia lagise, thik ase, ruling party majot kiba alop tanav hoise ba kiba alop lagise, so on the basis of that governor cannot recommend the president that a government khane properly work kori thaka nai apuni president rule impose kori do. That cannot be a criteria for imposition of president's rule. Okay, next. Okay, so next question jonto dise amar tar bitor ki dise not correct disaibo dise, kuntu correct nohoy. Adjournment motion can be introduced in Lok Sabha only, this is right. No confidence motion can be moved against individual minister or the entire council of minister, this is not correct. Censure motions can be moved against entire council of ministers only. So in case of moi koise only jot byavar hoy, basically those statement bilak generally ki hoy not correct hoy. So option D is not correct here. Option D is the answer and option statement 2 and 3 are not correct. Explanation jodi sai, no confidence motion can be moved against the entire council of ministers only, okay, not individual. Aru censure motion individual minister or entire council of minister, etu kotha monot rakhibo. This is the basic difference, no confidence motion aru censure motion. Okay, so next, in context of Indian polity, in which of the following matters can the governor act in his discretion? So you know there are certain powers which can be done by governor with his discretion. Okay, so but in case of president there is an act, Constitutional Amendment Act, I hope you know, you can write it also in my comment box. So aid and advice of Union Council of Ministers is binding on the president boli eta Constitution Amendment Act provisions to anisile. In case of president মোক এটো আপোনালোকে কমেন্ট বক্সত জনাব। বাট ইয়াত কি কৈছে, গভৰ্ণৰে নিজৰ ডিসক্ৰিপশনত কৰিব পৰা কাম কোনকেটা হয় বুলি এটা মানে সুধিছে। ওকে, submitting a report to the president under article 356 on the failure of constitutional machinery of the state, this is correct. Reserving the bills for consideration of the president, amar already news to ase matter to, so also article 200 বা article 201 ekita আপোনালোকে ভালকে পঢ়িব, ঠিক আছে। Appointing a chief minister if no single party has secured majority in the state legislature, this is also right. So here 1 2 3 are also all are correct here. Okay, explanation jodi sai under article 163 governor discretion or kotha ullekh ase in certain matters. Exercising the power given by the governor of Assam under para 9 of 6th schedule, exercising the functions of governor for appointing for appointment of an administrator of an union territory under article 239 section 2 subsection 2. Special responsibilities are assigned to the governor of various states under the provisions of article 371. Submitting a report to the president under 356 on the failure of constitutional machinery in a state. Reservation of bills for consideration of president under article 200, this is very important, nowadays it is in question. Landmark judgment eta dile recently. Appointing a chief minister ki dile, time bound dile, have you heard about it? What is the time bound that has been given by honorable court? Kiman din reserve koribo paribo etu apnaloke ebar sabo. Okay, then in all other matters he has to act on the advice of the council of ministers. Appointment of members of the state election commission is done with the advice of council of ministers in this case, ঠিক আছে। 61 of this, which of the following is বা are correct regarding prime minister of India? The constitution does not contain any specific procedure for selection of appointment of prime minister, this is correct. Term of prime minister is not fixed, okay, not fixed, he holds the office during the pleasure of president. However imanu easy nohoy prime minister of remove kora, karon hetu karone teo ki house of confidence lose koribo lagibo, okay। He gets the salary and allowances that are payable to the members of parliament. Members of parliament MP সকলে যেনেকৈ salary লয় তেওঁৰ provisionটো একে. He just leads the ministers, okay, বা council. He can ask the minister to resign or advise the president to dismiss him in case of difference of opinion. Definitely, karon সকলো council of minister they are individually also responsible, right, for their deeds. Explanation jodi koy, the term of prime minister not fixed, holds the office during the pleasure of the president. However, this does not mean that president can dismiss prime minister at any time. So long as the prime minister enjoying the support on Lok Sabha, he cannot be dismissed. However, jodi tekhete confidence lose kore tetia in that case president can dismiss him ba teo resign koribo lagibo. Okay, next question, which of the following is or are correct regarding article 75 of Indian constitution? Okay, the prime minister shall be appointed by the president and the other council of minister must be appointed by the president on the advice of prime minister. This is true. There shall be council of minister with the prime minister at the head to aid and advise the president. So this doesn't come under article 75. The minister shall hold the office during the pleasure of the president. This doesn't come under article 75. It shall okay. The minister here ki dise, this is correct hodise na. Okay, just a second. 1 to correct hoy. 3, the minister shall hold the office during the pleasure of president. This is right. So 1 and 3 are correct. 1 and 3 are correct. Okay, 4 to Samami. It shall be the duty of prime minister to communicate to the president all decisions of the council of ministers relating to the administration of affairs of the unions and proposals for registration. They to 75 or under nahe. So there are 3 important duties. Prime minister 3 important duties ase in regards to the ki hoy president. Hetu 75 or under nahe. Tothapi tu moi ebar ekdom easy bhashat bujai disu. Number 1, GG administration choli ase, GG legislation or kaam choli ase, president ok janabo lagibo. Number 2, jodi president e bisare কোনো এটা টাইমত যে কি কাম চলি আছে এডমিনিষ্ট্ৰেচনৰ কেনেকৈ আপোনালোকে পৰিচালনা কৰিছে তাৰ বিষয়ে মোক জনাওক। ওকে, এটা হল নিজে জনাব লাগিব, এটা হল বিচাৰিলে জনাব লাগিব প্ৰেসিডেন্টে, আৰু এটা কোনোবা এজন মিনিষ্টাৰে যদি কাউন্সিল অফ মিনিষ্টাৰক নজনোৱাকে কোনো ডিসিশন লয়, সেই ক্ষেত্ৰত প্ৰেসিডেন্টে যদি ভাবে কি গোটেই কাউন্সিল অফ মিনিষ্টাৰক জনোৱাটো নেসেসারি হয়, হি মে ডাইৰেক্ট দ্য প্ৰাইম মিনিষ্টাৰ দ্যাট you please ask him to place all his proposals etc before the council of minister. So these 3 things are there. Eto apnaloke belek ke monot rakhibo lagibo. Okay, article 76 or under monot rakhibo lagibo hetu. So there shall be a council of ministers with prime minister as the head to aid and advice of the president. It comes under article 74 or last to moi koa dore article 76 or under ahe. Thik ase, next, which of the following is or are regarding not correct regarding the cabinet or regarding kuntu correct nohoy hetu khudise. So if you see the general structure apnaloke jane nohoy, if I consider this as a council of minister, tar bitorot cabinet thake, tar bitorot deputy minister thake hone nohoy, tar bitorot other group of minister thakiba pare hone. So although gutekhini amar cabinet council of minister bitor jodiu kumai thake, tothapitu cabinet is the most powerful body আৰু ক্যাবিনেটে যিখিনি ডিসিশন লয় সেই ডিসিশন মতে গুটেই কাম প্ল্যান এন্ড পলিসি বিলাক ইমপ্লিমেন্টেশন কৰাৰ দায়িত্বটো কাউন্সিল অফ মিনিষ্টাৰৰ আহি পৰে। ওকে, সো ইট ইজ এ পাৰ্ট অফ কাউন্সিল অফ মিনিষ্টাৰ। নট কাৰেক্ট কৰিছে, দিস ইজ ৰাইট। ইট ডাইৰেক্টস দ্য কাউন্সিল অফ মিনিষ্টাৰ্স বাই টেকিং পলিসি ডিসিশন হুইচ আৰ বাইন্ডিং টু অল দ্য মিনিষ্টাৰ। তেওঁলোকে এটো মানিব লাগিব বিকজ দিস ইজ ক্যাবিনেট ডিসিশন। It was inserted in the article 352 of Indian Constitution in 1978 by 44th Constitutional Amendment Act. This is also right. Aru, it enforces the collective responsibility of the council of minister to the lower houses of the parliament. Amane Lok Sabhar kotha koise. All these statements are correct. So cabinet or kotha apnaloke poribo lagibo. Aru also how cabinet is different from council of ministers. If you have already differentiated it, then you can study about it also. Thik ase. So explanation of Chawapara is a smaller body consisting of 15 to 20 members. Cabinet pohar loge loge apnaloke kitchen cabinet or kothao pohi lobo. Thik ase, kitchen cabinet of informal member thakibo pare niki, jun manu cabinet thake tar bahiror manu thakibo pare niki, prime minister friends and family include hobo pare niki. Okay, so hibilak postu apnaloke sai lobo in the case of kitchen cabinet. It includes cabinet ministers only, thus it is a part of the council of ministers. It meets as a body very frequently and usually once in a week meet kore, hetu to ami janwe, aru important decisions and functions bilak important decisions বিলাক লয় আৰু functions বিলাক ensure কৰা responsibility council of minister আহি পৰে and they are directly responsible to the Lok Sabha. Okay, cabinet committees, political affairs committee, economic affairs committee, appointments committee, parliament affairs committee, which of the following is not correctly matched? Headed by, okay, so আপোনালোকে এটা কথা মনত ৰাখিব, there is a চাৰিখন important committee বুলি কোৱা যায়, cabinet committee কথা কৈছে, ইয়াৰে তিনিখন prime minister head কৰে, ঠিক আছে, আৰু এখন home minister head কৰে, তেনেকে যদি মনত ৰাখে first point of মানে memory is that only. Next আপোনালোকে এটা বস্তু মনত ৰাখিব, ইয়াতে কি কৈছে not correctly matched বুলি কৈছে, so this is headed by prime minister. Economic affairs কোনো কোনে হেড কৰিব আৰু আমাৰ যোনখন appointments committee আছে এখন কোনে হেড কৰে, same মানুহজনে তিনটা কমিটি হেড কৰে আৰু এখন হোম মিনিষ্টাৰ হেড কৰে, আমি চাম এতিয়া। তো ইয়াত 2 3 4 not correct হয়, 1 is correctly matched. Political affairs committee, economic affairs committee, appointments committee কাম বিলাক দি দিছো, parliament committee কি কাম কৰে এই গুটেকেটা কাম দি দিছো, কেতিয়াবা এইকেটাও match দি following আহিব পাৰে, cabinet committee and their work. Okay, so first three committees মানে political affairs committee, this is the most powerful committee, okay. Then economic affairs committee or appointments committee, these all are headed by prime minister. And to the last one মানে parliamentary affairs committee, this has been headed by home minister. ঠিক আছে, এটো আপোনালোকে মনত ৰাখিব। Then 56, which of the following devices of parliamentary proceeding are correctly defined? Shared question, unshared question, or short notice question. Okay, shared question requires an oral answer and hence supplementary questions can follow. This is correct. Okay, an unshared question is one that is asked by giving a notice to less than 10 days. So this is short notice. Okay, this is not wrong, this is not correct. A short notice is a question that requires written answer and hence supplementary questions cannot follow. This is unshared question. So ketiaba question to eneke baibo pare ki shared question or karone unshared question or karone apnalokor written answer lagibo ne orally koleo hobo. So eneke dhorone statement ahibo pare, ei karone moi gute keta eneke di disu, yar majoto apnaloke sub question create koribo pare. So in this case only one is correct. Okay, so if you see the unshared question, then you will get that it requires a written answer and hence supplementary question cannot follow. Okay, agote written reply koribo lagibo je we are asking about unshared question. Okay, short notice ki hoy, this is it has been asked by giving a notice of less than 10 days. It is answered orally, it is not answered in written, it is answered orally. Okay, so these are the distinguished features actually, short notice hok, unshared question hok. So joint sitting of parliament over next question I say, joint sitting is an extraordinary machinery provided by the constitution to resolve a deadlock between the two houses over passage of bill. This is correct. The speaker of Lok Sabha can summon both houses of the parliament to have a joint sitting for the purpose of deliberating and voting of the bill. This is also correct. Okay, the provision of joint sitting is applicable to ordinary bills, financial bills and money bills, but not to constitutional amendment bills. No, this is not correct. This is not correct. Okay, this is not correct. If the bill under dispute has already lapsed due to dissolution of Lok Sabha, no joint sitting can be summoned. Already jodi lapse hoy goise, joint sitting bohai to lam nai. Okay, so 1 2 4 and correct only, 3 is not correct because ordinary bills, financial bills tar karone he pare okol, juntu amar money bill ase বা constitution amendment bills ase tar karone this is not applicable. Okay, in case of money bill, the Lok Sabha has overriding powers, while a constitution amendment bill it must be passed by each houses separately. Okay, can constitutional amendment bill be introduced in respective state legislature or state legislative council? মোক এটো comment box ত আপোনালোকে জনাব। Next question number 67. Parliamentary Accounts Committee kotha, that is also one of the important committee. Estimate committee kotha ignore kori diu kintu keteba ahi jaba pare. So chairman of the committee is appointment by the speaker among his members and is invariably from the ruling party, number 1. Number 2, function of the committee is to examine the estimates included in the budget and suggest economies in public expenditure. All 30 members are from Lok Sabha only. A minister cannot be declared as a member of this committee. Here all of the above options are correct. 67 মই এটা মার্ক কৰিব পাহৰি গৈছো, but option D is correct. ঠিক আছে, এটুত আপোনালোকৰ কনফিউজন লাগিব পাৰে কাৰণ প্ৰথমতে 25 জন মেম্বাৰ আছিল, তাৰ পিছত 30 জনলৈ ৰেইজ কৰা হ'ল হয়নে, আৰু all 30 members are from Lok Sabha only, term 1 year হয়, আৰু a minister cannot be elected as a member of this committee. ঠিক আছে, next 50 or 69 number question. Which of the following is or are correct regarding judges দুবাৰ হৈ গৈছে, judges of the Supreme Court of India, he or she can resign his office. So ইয়াতে কি সুধিছে, correct সুধিছে, resign from his office by writing to the president. This is correct. A judge of Supreme Court can be removed from his office by an order of Chief Justice of India. No. Okay, last thought removal to kune kore, we'll study about it. The Judges Enquiries Act regulates the procedure relating to the removal of judges from the Supreme Court by the process of impeachment. So this process is also this time very important because recently High Court judgeor removal or report to আমি articles পঢ়ি আছো. Okay, so question number 2 to কিহৰ কাৰণে correct নহয়, because this is by President of India. After all these enquiries, approval, then finally order of the President of India removal, not Chief Justice of India. Okay, so next question number 70. Which of the following is or are correct regarding Indian Supreme Court বা Supreme Court of India? আকৌ Indian or Supreme Court of India দুটা শব্দ লিখা গৈছে. Its original jurisdiction is confined to federal cases. Okay, its appellate jurisdiction is confined to the constitutional cases only. This is not correct. It has its advisory jurisdiction. Definitely, the scope of judicial review is limited. Yes, this is also true. Now here option B, 1, 3 and 4 are not correct. And now appellate jurisdiction jotu hoy, it covers both constitutional, civil and criminal cases. It is not confined within a particular civil cases বা particular criminal cases. Okay, so তেওঁলোকে constitutional case ওপৰত jurisdiction আছে বা try কৰিব পাৰে, civil case try কৰিব পাৰে and criminal case try কৰিব পাৰে. Okay, it defends the rights of citizen according to the procedure established by law. এটো কেতিয়াবা আহিব পাৰে, basic principle. Okay, its jurisdiction and powers can be enlarged by parliament. This is one of the most important thing. কেতিয়াবা সুধিব পাৰে কি only Supreme Court he nijor juntu jurisdictionary power hetu increase koribo pare by passing certain orders, teneke kitiaba ahibo pare, but this is not correct. Actual jodi jurisdiction or jodi kotha koy, power or jodi kotha koy, it can be enlarged by parliament. Okay, its power of judicial superintendence and control over state high courts are due to integrated judicial system. Judiciary apnaloke poise, we are having integrated judiciary. Thik ase, that's why it has power to superintendence and control. Superintendent to koribo pare, control to koribo pare high court opor. Now yate aru eta bostu important hoi jay, ki important hoy, writs. Can Supreme Court using suo motu power transfer any case from a subordinate court to them, or if yes, does it fall under any writs? Okay, so মোক এটো কমেন্ট বক্সত আপোনালোকে জনাব. 71 article 133, 34, 35, 36 and 143 match the following কৰিব দিছো. 133 appellate jurisdiction of Supreme Court in civil cases, this is right. 134 appellate jurisdiction of Supreme Court in criminal cases. 136 authorizes Supreme Court to grant special leave to appeal from any court or tribunal except military tribunal and court martial. This is also correct. 143 authorizes President to seek the opinion of Supreme Court on any question of law or fact on any pre-constitutional legal matters. This is also in news due to what? So whenever you are studying article 200 and 201 these days, Also please study the provision that is written in article 143. So due to a landmark verdict, এতিয়া মই এটো আপোনালোক বুজাই দিবলে সময় নাই, কিন্তু 200 or 201 টো আপোনালোকে পইছে। Now this article 143 is in news also. Okay, so all of the above statements are correct. Question number 72. Justice, which of the following statements are not correct? Justice V.R. Krishnaiyer and P.N. Bhagavati Wada, they are pioneers of POL. The concept of PIL originated and developed in Britain. This is also true. Service matter and those pertaining to the pensions and gratuity are not entertained under PIL. Yes, this is not. This is also correct. PIL can be filed against petitions against police for refusing to register a case, harassment by police, and death in police custody. This is also right. But the question is, which of the following is are not correct? That means none of the above are not correct. Okay, so option D is correct here. So the cases falling under the following categories will not be entered in as PIL. So if you are smart enough, then you will study which of the following cases that doesn't fall under PIL. Karon the cases which are included under PIL but which are falling under the purview of PIL are long one. So why do you remember that? Just remember this one. Porikar option jodi egetar bahire ahe, then you will get to know that this can be filed under PIL, but in this matter PIL can be filed. So just 5টা point আছে plus hey উপৰৰ যিটা provisions আছে সেই provisions কেটাৰ লগত আপুনি compare কৰি লব। Landlord tenant matters, service matter and those pertaining to pensions and gratuity, admission to the medical and other educational institution, petitions for early hearing of cases pending in the high courts and subordinate courts, complaints against central state government departments and local bodies except those which are eligible under PIL. Okay, so this sentence here is also important. There are certain provisions in for filing PIL in certain matters that falls under the central or state governments. Those matters which are not under the purview of PIL, those matters can be entertained. You know, আপোনালোকক মই আকৌ বুজাই দিও, there are certain matters, কিছুমান matter PIL or under কি কৰিব পাৰে, you can file an PIL, but in certain matter, in other matters, suppose these are other matters, ekhini PIL central government or state government or ekhini matter PIL to ami involve korbo nuaro ba apply korbo nuaro. So ei matter khinir bahire jikhini matter ekhini matter ki koise excluding this matter, tamane ei matter khini ami PIL file korbo paru aru baki jonkhini remaining matter ase ekhini PIL under entertain korbo nuare. Okay, just question will come in this way only. Okay, 73 reads or kotha hodise article 226 of Indian Constitution empowers, not correct hodise ha, a high court to issue writs. Yes, so high court aru supreme court or writor power 226 e hok 32 e hok telok comparative analysis e hok car jurisdiction besi tar upor question ahe generally. The writ jurisdiction of high court is not exclusive but concurrent with the writ jurisdiction of Supreme Court. Okay, so yes, this is also correct, this is also correct. The writ jurisdiction of the Supreme Court is wider than that of High Court. This is not correct, this is not correct. Okay, the writ jurisdiction of both the High Court and the Supreme Court constitute a part of basic structure of Indian Constitution. Okay, so have you heard about a Chandra Kumar case, L. Chandra Kumar case? Have you heard? Okay, regarding tribunal NCLD, have you heard about it? Then you will also get to know that this sentence has been used. The a sentence to use kora hoisile by a sentence to reference dia goisile ki writ jurisdiction of High Court, it falls under basic structure of Indian Constitution. Okay, so this is also one of the important sentence. So here 3 only is not correct. Okay, writ jurisdiction of High Court is greater but wider than Supreme Court. Because Supreme Court can issue writs only for enforcement of fundamental rights, only for fundamental rights, The writs are under purview of Supreme Court, but not for any other purposes. But in case of high courts, ordinary legal rights or kothao ba no ki koise enforcement of the fundamental rights and not for any other purpose. That is, it does not extend to the cases where breach in ordinary legal rights is alleged. Ordinary legal right bula violate hoise, you cannot move a writ to the Supreme Court. But in that case, you may go to the High Court. So the scope is greater. In this case, the scope of writ jurisdiction is wider in Higher Court than Supreme Court. Next, which of the following is or are not correct about tribunal? 42nd Constitutional Amendment of 1976, Part 14A, Tribunal add korise. This is right. The Administrative Tribunal Act in 1915 authorizes central government to establish Central Administrative Tribunal and the State Administrative Tribunal. Is it right? Is it 1950? So this is not right. ठीक है? The Central Administrative Tribunal exercises original jurisdiction in relation to the recruitment and all India matters of public servants covered by it. Administrative Tribunal Act of 1985, okay, here diye disu 1985, empowers the state governments to establish state administrative tribunals. Okay, so this is also not right. State government cannot establish state administrative tribunal. Central government can establish. Now, why central government is only authorized to establish state administrative tribunals? It doesn't, I don't think it will come in prelims, but for mains, you can take a note of that. Okay? In foundation, actually, I was doing that classes. Administrative Tribunals Act 1985, not 1950. It authorizes central government to establish central administrative tribunals and state administrative tribunals. Okay? So it authorizes central government. In case of SAT also, state administrative tribunals also is the power of central government only. The Administrative Tribunals Act of 1985 empowers central government to establish state administrative tribunals on specific request of the concerned state government. Next question. Which of the following is or are not correct about Gram Nyayalayas? I already আপোনালোকক কৈছিলুৱে ADRs or বিষয়ে পঢ়িবলৈ কাৰণে Family Court, Gram Nyayalayas আৰু Lok Adalat. Okay? Gram Nyayalayas Act 2008 not correct kudise. Has been enacted to provision for the establishment of Gram Nyayalayas at the grassroots level. This is correct. Gram Nyayalayas shall be court of judicial magistrate of first class and its presiding officers shall be appointed by the Chief Justice of respective High Court. This is not correct. But the first portion of the sentence is correct. So, without studying the whole sentence, you please do not tick correct. Okay? Because he should be a judicial magistrate first class. So, I think apnaloke hierarchy to jane. CJM বা judicial magistrate থাকে, judicial magistrate first class and second class থাকে. So he should be appointed as a ন্যায়াধিকাৰী. ঠিক আছে, সেইটোবোৰ ঠিকই আছে, কিন্তু he is not appointed by chief justice. Okay, the Gram Nyayalayas exercise the powers of civil courts only. No, they can also try criminal cases. Okay, the appeal against the decision of the Gram Nyayalayas in regards of civil cases may lie in the district court. আৰু যিবিলাক criminal cases থাকে তাৰ এগেইনষ্টত যদি গ্ৰাম ন্যায়ালয়ে দিয়া এৱাৰ্ডটোৰ এগেইনষ্টত you can move to the respective session court. এইখিনি আপোনালোকে I hope you have completed it. So he is appointed by state government in consultation with the High Court. Okay, the Gram Nyayalaya shall try criminal cases, civil suits and claims and disputes. Okay, so criminal cases are also there specified in the first schedule and the second schedule of this act. Which of the following is correctly matched? 371, 371A, 371C, 371B. Special provision to the states. Okay, 371 here ki hoche not correctly matched. 371 monot rakhibo Maharashtra and Gujarat. 371A Nagaland. 371C Manipur. 371D Assam বুলি ভাবি পেলাই সকলে আসাম ঠিক কৰি দিব, কাৰণ ভাবিছে সকলো নৰ্থ ইষ্টাৰ প্ৰভিজনে সুধি আছে। ঠিক আছে, মই কিন্তু ইয়াতে হেতু কাৰণে অসমটো জানি বুজি ভুলকে ইয়াতে ভৰাই দিছো। So 4 is not correct. This article 371D is for Andhra Pradesh and Telangana. Okay, 371B that deals with Assam. Now can you distinguish the special provision in case of northeastern state or jikekhonok special provision dia ase aru jikekhon other states of mainland India, okay, other than northeastern state boli moi jikekhon koisu, which are not false ba which are not included in the northeast. So সেই state khon aru northeaster state or special provisions je dise, ইয়াৰে এটা ডিস্টিংগুইশিভ মোক এটা আপোনালোকে ফেক্ট ক'ব পাৰিবনে কিহৰ ওপৰত ডিস্টিংগুইশ কৰিছে নৰ্থ ইষ্টাৰ্ণ ষ্টেটছ বিলাকক যোনটো স্পেচিয়েল পাৱাৰ দিছে এটো সাৰ্টেইন এটা সাবজেক্টৰ ওপৰত দিছে বা এটা মেটাৰৰ ওপৰত দিছে কমন মেটাৰ্স কিছুমান আপোনালোকে পাব আৰু আদাৰ যোনবিলাক ষ্টেটছ আছে তেওঁলোকৰ স্পেচিয়েল প্ৰভিজনছ বিলাক কিহৰ কাৰণে দিছে so if you analyze it then you will get to know. Okay, so অকল মুখস্থ কৰিলে নহব যে কিহৰ কাৰণে প্ৰভিজনছ বিলাক দিছে প্ৰভিজনৰ এনালাইসিসটো আপোনালোকে কৰিব লাগিব Okay, so next question, Metropolitan Planning Committee kotha aise. One half of the members of the Metropolitan Committee should be elected by the elected members of the municipalities and chairpersons of the panchayat in the metropolitan areas. Should it is it 1/4 or 3/4? Okay, ekhini apnaloke hoyto pohise municipality chapter tote ase last ro pina pohise na naiba. The state legislature may make provisions for composition of Metropolitan Committee. So which of the following is not correct? This statement is not correct. This is true. Okay, so here option A is correct. Explanation jodi sai the state legislature eto power ase composition kini soa manner of election keneke hobo representation keneke hobo central government state government and other institution organization of keneke teolokok member kini tate join hobo thik ase functions of such committee in relation to the planning and coordination with the metropolitan area keneke hobo that will be also determined by state legislature. Okay, the manner of election of chairperson of such committee will also be decided by the state legislature only. ठीक है, so it lays down that this is 2/3. This is 2/3. So people confuse between one half বা আপোনাৰ 3/4. Okay, so hetu karone this is remember this is 2/3 members of the Metropolitan Planning Committee should be elected by the elected members of the municipalities and chairperson of panchayat. Okay, and কৰ পৰা কিমান জন মেম্বাৰে এই 2/3 to constitute কৰিব will determine state legislature only. Which of the following is or are not correct? Okay, not correct. The state government is empowered to declare an area as a scheduled area. Is state government or president? The respective state government has a special responsibility to submit a report to the state government. Governor state government of report dibo boli koise regarding the administration of such areas annually or whenever so required by the state government. Is it state government nohoy to president of India? So all of the above are not correct. Explanation to Silok. The president is empowered to declare an area as a scheduled area. He can also increase or decrease the area by alter the boundaries. Governor has a special responsibility in regards of such area. He has to submit a report to the president regarding the administration of such areas. So he has to report to the president. Which of the following is are not correct about features of administration contained in 6th schedule of Indian Constitution? Okay, kuntu not correct koriche. The tribal areas in 4 states of Assam, Meghalaya, Tripura, Mizoram have been constituted as an autonomous districts. So here definitely ase district ekhono ki naam apnaloke jane ne autonomous district council bilakor naam ekhini apnaloke ebar sai lobo. The governor is empowered ba kunkhon state ot kiman khon ke ase. The governor is empowered to organize and reorganize the autonomous districts. This is also correct. So yate ki hoche not correct. So none of the above are not correct. Okay, so condition for fulfilling national party বা state party খুবই important. If it secures কোন কেটা correct করিছে 6% of valid votes polled in favor of 4 or more state at a general election of Lok Sabha or to the legislative assembly, and in addition to the it wins the 4 seats in the Lok Sabha from any state or states. This is right. if it wins 2% of seat in Lok Sabha in a general election and these candidates are elected from 3 states, this is also right. If it is recognized as a state party in 4 states, so all of the above are correct here. So state party, yes, state party question dia goise, state party hobole kuntu question bhul hetu kudise. If it secures 8% of the valid votes, it is 8 or 6%. In the state at a general election to the legislative assembly of the state concerned, and in addition to the it must win 2 seats from the assembly of that state legislative assembly. Okay, it secures 6% of the valid vote polls in the state at a general election to the Lok Sabha from the state concerned, and in addition it wins 1 seat of the Lok Sabha from the state concerned. If it wins 3% of seats, this is also correct. If it wins 1 seat in Lok Sabha for every 25 seats for a fraction thereof allotted to the state at a general election to the Lok Sabha from state concerned, this is also correct. So here not correct kudise, so 1 is not correct. Okay, so it should secure 6% of the valid votes polled. Aru logot remaining point jodi sai 1 2 3 4 to dia gese 5 aru eta point sawa pare. If it secures 8% of total valid votes polled in the state general election to the Lok Sabha from the states or to the legislative assembly of the state, this condition was added in 2011. So hetu ketiba khudibo pare ei provision to kun sonot add kora goisile, so 2011 er kotha apnaloke kobo pare. So either of this condition can if one party fulfills, then they will be recognized as state party. Which of the following statements are not correct? A candidate contesting in an election to the Rajya Sabha from a particular state should be an elector of that particular state. So this is not correct. A member of the scheduled caste or scheduled tribes cannot contest a seat into the Lok Sabha not reserved for them. Not correct. In Rajya Sabha, seats are reserved for scheduled caste and scheduled tribes as per the 4th schedule of Indian Constitution. This is also not correct. Okay. So 1 2 3 here. আমি এবাৰ চাই দিও কনস্টিটিউশনে কি কৰিছে কোয়ালিফিকেশন অফ পারসন টু বি চুজেন এজ দা মেম্বার অফ পার্লিয়ামেন্ট কেটা চাই লও আৰু আরপিএফ কি কৈছে হে প্ৰভিজন কেটা চাই লও ওকে কনস্টিটিউশনে কি কৈছে হি মাস্ট বি a citizen of India, so he must make and subscribe an oath of affirmation authorized by the election commission for this purpose before that person. He must not be less than 30 years in case of Rajya Sabha, not less than 25 years in case of Lok Sabha. He must possess other qualification that has been prescribed by Parliament. RPA ki koise he must be registered as an elector for parliamentary constituency. This is the same in case of the both Rajya Sabha and Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an elector of that particular state was dispensed within 2003. Hence statement 1 is not correct. Buji palane 2003 koise ki it is not necessary. This is number 1 question. Number 2, he must be a member of scheduled caste and scheduled tribe in any state or Union territory if he wants to contest in a seat reserved for them. But jodi reserved na thake, still they can contest. Okay. However, a member of scheduled caste or scheduled tribe can also contest a seat that is not reserved for them. This is the common kotha, hoine nohoy. The Rajya Sabha, in the Rajya Sabha, seats are not reserved for scheduled caste and scheduled tribes. Hence, statement 3 are not correct. Okay. So Rajya Sabha kuno seat reserved na thake. So Lok Sabha or state legislature Anglo-Indian or reservation ক্ষেত্ৰটো question আহিব পাৰে by which constitution amendment act আৰু কিমান কে provisions আছে এটো কাৰণে মই ইয়াৰ লগতে আপোনালোকক কৈ থৈছো. 83 number question, consider the following statements about leader of opposition. So কোন কেটা correct কৰিছে? The office of the leader of opposition is not mentioned in the Indian Constitution. They entitled to the salary allowances and other facilities equivalent to that of a cabinet minister. Both the statements are correct here. So leader of opposition er kotha apnaloke alop poribo because this is also important and aru in certain cases jodi leader of opposition na thake tetia kak leader of opposition hisabe consider koribo সেই case keto apnaloke bhalke poribo thik ase. The offices of the leader of house and the leader of opposition are not mentioned in the Indian Constitution as aru ki koise they are mentioned in the rules of house and parliamentary statute respectively. Hence statement 1 is correct. Leader of the house, under the rules of Lok Sabha, the leader of the house means prime minister if he is a member of Lok Sabha or a minister who is a member of Lok Sabha and is nominated by a prime minister to function as the leader of the house. Okay, etu ami leader of the house er kotha koisu. Okay, there is also a leader of the house in Rajya Sabha also. He is a minister and a member of Rajya Sabha and is nominated by the Prime Minister, okay, to function as the same way. এখিনি মনত ৰাখিব ইম্পৰ্টেন্ট কাৰণে মই দি দিছো leader of opposition ৰ কথা যদি আমি চাও in each house of the parliament there is a leader of opposition. Okay, so leader of opposition কেনেকৈ চুজ কৰা হয়? The leader of the largest opposition party having not less than 1/10 of the total strength of the house is recognized as the opposition in that house, আৰু সেই oppositioner leader জনক generally leader of opposition হিচাপে চুজ কৰা যায়. His main function are to provide constructive criticism of politics of the government and to provide alternative government. Okay, they are also entitled to the salary allowances and other facility equivalent to the rank of cabinet minister. Hence statement 2 is correct. Okay, next we will go to the question number 84. Speaker of Lok Sabha karone kuntu statement শুদ্ধ হৈছে? He can be removed by a resolution passed by an effective majority of all the members of parliament. No. Okay, he resigns by writing to the President of India. This is also not correct. When a resolution for removal under consideration of that house, he cannot take part in the proceeding of that house. No, this is also not correct. Whenever the Lok Sabha is dissolved, the Speaker does not vacate his office and continues till the newly elected Lok Sabha sits বা meets. Okay, when Lok Sabha meets, jeta notun Lok Sabha to arambho hobo tetialeke teo function kori thakibo. So this is also correct. Okay, so statement 1 A, B, C are not correct because it is elected from the Lok Sabha from amongst their members. Whenever the office of the Speaker falls vacant, Lok Sabha elects another members to fill that vacancy. Number 1. Number 2, the date of the election of the Speaker is fixed by the President of India. Usually, Speaker remains in the office during the life of the Lok Sabha. However, he has to vacate his office earlier in case of following cases. A case ketat teo nijor office to agote vacate kori dibo pare. If he ceases to be a member of Lok Sabha, jodi teo aru Lok Sabhar member hoi nathake titia teo eri dibo lagibo. Thik ase? If he resigns by writing to the Deputy Speaker, not to the President. Okay, this is very important and confusing. Ketiaba question eto bhul hoi jay. If he is removed by a resolution passed by effective majority of all members of the Lok Sabha, not by the both houses. Okay, such resolution can be moved only after 14 days advance notice. 14 days advance notice o tar karone tiketok dibo lagibo. When a resolution of removal of Speaker is under consideration of the house, he can preside at the sitting of the house. Okay, whenever the Lok Sabha is dissolved, Speaker does not vacate his office and continues to the newly elected Lok Sabha. That is also correct. Okay, sir. These are important provisions. Okay, so which of the following are correct? To say privileges of a state legislature are extended to which of the following? Okay, Governor, Chairman of the Legislative Council, members of Legislative Assembly, members of Legislative Council, Advocate General of the state. This is correct. This is correct. This is correct, and this is correct. Governor to no hoy. ठीक है sir. So, privileges of the state legislature are special rights, immunities and exemptions that are enjoyed by the houses of respective state legislature. ठीक है sir. These privileges are necessary to maintain to dignity and decorum of that house. Aru constitution le ki korise? It has extended these privileges to the person that are entitled to speak and take part in the proceeding of the house of the state legislature. Okay, only to those person these privileges are reserved. বুঝি পালে নে? These privileges are not extended to the governor, who is an integral part of state legislature. Although the governor is an integral part of state legislature, but this privileges is not extended to him. Proceedings bilakot to governor e goi pelai অংশগ্রহণ কৰি নাথাকে, right? So next question 86, duration of municipality kotha koise. The act provides which of the following is are correct? This act provides 5-year term for every municipality, right? It is constituted upon dissolution. That will municipality constituted upon the dissolution shall continue only for the remaining period. Also there is a jodi apuni hetu question olop tough hisabot jabo khuje, then 6 months or bhitorot dissolve hua aru 6 months nathakute dissolve hua duta condition ahi jay. So yata normal condition to hudise je ekhon municipality, suppose a municipality kon December dissolve hobo loga asile, okay, aru dorok 6 months or time frame or bahirot teoluk dissolve hoi gol, tar mane 7 mah baki ase dissolve hobole. Tetia ki hobo? Jodi by chance election hoy, for that remaining period only those new body can function. Okay, আৰু যদি উইদিন 6 months হয় নিউ বডি উইল ফাংশন ফৰ দ্য নেক্সট টার্ম কমপ্লিট টার্ম okay which among the following is not a feature of election system of India universal adult franchise is an integral part representation of weaker sections limited political competition is never there aru one vote one value so option C is correct here one open political competition anyone can form a party and contest elections hoine aru tar karone contest koribo karone ki eta teluke security deposit dibo lage ajikali state legislature MP karone security deposit ase niki jodi ase kiman hoy aru kiman percent vote secure koribo lage jodi apni hareo he security vote deposit tu jate apni वापस पाई जाए बा घुराई पाई जाए एखिनि आपनलके एबार मन करिब ठीक আছে 88 नंबर क्वेश्चन not will not be a cause for disqualification for defection কোনটো cause নহয় সো RP Act 1951 X বিলাক ভালকে পঢ়িব বিশেষকে আপোনালোকৰ স্পেসিফিক এক্ট সো যিসকল ফাউন্ডেশন আছে তেওঁলোকক মই স্পেসিফিক কিছুমান সেকশনস কৈ দিছো যেনে সেকশনস 8 এটা ইম্পৰ্টেন্ট সো এটা কৈছে disqualification to kuntu cause of valid nohobo if a nominated member joins a political party within 6 months of his or her becoming member of legislature so a cause to tetia valid nohobo option D is correct next 89 number question consider the following statements in context of calling attention motion it is introduced to deal with very important matters like impeachment of the so kuntu correct to dise introduced to a very important method like impeachment of president this is not correct it is an Indian innovation in parliamentary procedure this is correct okay so similarly question regarding zero hour can also become okay calling attention motion to jodi apnaloke sai it is introduced by parliament by members to call the attention of the minister to matter of an urgent public importance and to seek an authoritative statement for him on that respective matter okay that's why statement 1 is not correct okay it is an Indian innovation in the parliament procedure and has been in existence since 1954 however unlike zero hour it is mentioned in the rules of procedure and statement 2 is correct a member cannot give more than 2 calling attention notices for one sitting it to all important sentence jodi statement based question ahe ejon member e keita dibo pare boli jodi ahe tara 2 callings can be given by him okay eta sitting o karne next question number 19 ordinance making power governor president duita balke sai lobo lagibo apnaloke thik ase ketia ordinance make koribo pare eta house dissolve hobo lage na duta house dissolve hobo lage eta house dissolve kora thakile jodi rajya sabha jodi special power thake titia hole itu house bohar ba lok sabha constitute hoar ba lok sabha first sitting or within kiman months teoloke approval koribo lage ketia lake ordinance validity thake ei gutekini apnaloke sabo libo it can so yete ki hoiche correct khodise it can repeal or modify any act of parliament okay so this is correct it can be issued retrospectively jodi 3 মাহ আগৰ পৰা এফেক্ট হৈছে সেই ডেটটো যদি ব্যাক ডেটত ইস্যু কৰিব পাৰে ৰেট্ৰস্পেক্টিভ এফেক্টৰ পৰা যে কনসিডাৰ কৰি লৈছো যে আগষ্টত আহিছে অৰ্ডিনেন্সখন কৈছে জুৱা ফেব্ৰুৱাৰীৰ পৰা এপ্লিকেবল হ'ব okay so hey retrospective যোনটো এফেক্ট এটো কনসিডাৰ হৈ যায় okay it can be issued on subject enumerated in the state list under ordinary circumstances it cannot be enumerated under ordinary circumstances etu monot rakhibo number 1 and 2 only 3 to rule during a national emergency the parliament becomes empowered to make law in the state list etu apnaloke jane karon main power constitute hoy jay center or hatot aru jitu amar feature ase etu ki hoy jay unitary hoy jay from federal okay while the proclamation of national emergency is in operation the president can issue ordinances on state subjects if parliament is not in session ঠিক আছে আৰু তাক লৈ পেলাই এটা কেছও হৈছিলে যে আপোনালোকৰ কেছটোৰ নাম আপোনালোকে মোক ক'ব যে মানে কি সেশনত পাৰ্লিয়ামেন্ট ষ্টেট লেজিসলেচাৰ নাথাকুতে মাল্টিপল অৰ্ডিনেন্স প্ৰমালগেট কৰিছিলে হেতু পিছত ইন এ পাৰ্টিকুলাৰ ষ্টেট তো হেতু পিছত ষ্ট্ৰাইক অফ হল আৰু ক'লে কি মানে ইন নৰ্মেল সার্কামস্টেন্সেস জাস্ট ষ্টেট এসেম্বলি ডিজলভ হৈ যোৱাৰ পিছতে গভৰ্ণৰে গৈ ডাইৰেক্টলি অৰ্ডিনেন্স ইস্যু কৰি থাকিলে নহব ওকে তো এনেকুৱা এটা কেছও আছে সো কেছটো কথা আপোনালোকে মোক জনাব কমেন্ট বক্সত sovereignty of Indian parliament report question aise written nature of Indian constitution 7th schedule of Indian constitution kun keta limit kore boli koise written nature yes 7th schedule of Indian Constitution, division of power kotha jodi koy, system of judicial review, fundamental rights. Okay, is fundamental rights is positive or negative for a state? Please give me in the comment box. And what is the relation with limitation and negative? Okay, etu muk janabo. So 1 2 3 4 all the options are correct here. Next 92 number question. Disqualification of member of panchayator karone ki question ki procedure follow hobo ba kontu correct hoy. A person can be disqualified under any law made by the respective state legislature. So in case of municipality also, state also, the power of state legislature is in certain terms it is supreme. ঠিক আছে, বহুতো ক্ষেত্ৰত in case of granting of funds, function, etc. So কি আছে, state legislature they have to permit, but they have to give instruction. Okay, so person shall be disqualified on the ground that if he is less than 25 years of age. Okay, this is not correct. All the questions of disqualification of the members of parliament shall be referred to the state election commission. This is not also correct. Okay, so a person shall be disqualified under any law for the time being that is being enforced for the elections to the legislature of the state legislature concerned. Etu number 1 to ketu karone correct hoy. Under any law made by the state legislature, however, no person shall be disqualified on the ground that if he is less than 25 years. ঠিক আছে, এখানে correct নয়. All questions of disqualification should be referred to such authority that has to be determined by state legislature. So in that case also, you cannot simply move to a authority that I am not permitted to contest in the election, but I am not permitted, but I have been disqualified from this provision. Okay, so state legislature will determine to which authority you will be going for their appeal purpose. Okay, so 93, which of the following can be identified as a major objective of Niti Aayog? Then fostering cooperative federalism, competitive federalism, cooperative federalism, definitely Niti Aayogor basic pillar hoy. Acting as a platform for resolution of interdepartmental issue, this is right. Integrating villages into developmental process, yes. To leverage India's democratic dividend. So all these options were correct here. Niti Aayogor question, Niti Aayogor publish kora reports ki ase heketa apnaloke ebar sai jabo. Okay, Niti Aayogor index to sai jabo. Index junto amar Niti Aayogor junto amar SDG related index ase tat ohomor performance bilakor opor apnaloke sai jabo. ঠিক আছে, কোড আমি পিছ পৰি আছো কোনটো SDG কোৱালিটি এডুকেশনত পিছ পৰি আছো নেকি? ওকে, বা ড্ৰপ আউট ৰেট আমি পিছ পৰি আছো নেকি? ড্ৰপ আউট ৰেট বেছি নেকি আমাৰ ইয়াত as per that index? কিখিনি বস্তু আপোনালোকে ভালকৈ চাব। আৰু SDG গোল কিমান আছে আৰু নীতি আয়োগ ইনডেক্সত কিমানটা গোল ফোকাস কৰি বনোৱা হৈছে, are they same or কম বেছি, এটো চাব। অবজেক্টিভ হয়, these are the objective, everyone knows about it. To foster cooperative federalism, develop mechanism to formulate credible plans to village level and aggregate progressive at the higher levels of government. So grassroots level or পৰা যেনেকৈ উন্নতি কৰিব পাৰো আমি সেটো ফোকাস কৰে নীতি আয়োগে জেনাৰেলি। টেকনলজি আৰু ক্যাপাসিটি বিল্ডিংত গুৰুত্ব দিয়ে হয়নে? To design strategic and long term policy and program framework initiative and monitor their progress and efficacy হয় না নহয়? To provide advice and encourage partnership between key stakeholders, collaboration of different departments, collaboration with different institutes, that also comes under capacity building. To offer a platform for resolution of intersectoral and interdepartmental issues in order to accelerate the implementation of developmental agenda, to leverage India's democratic dividend, all these are under the objective of Niti Aayog. So what can be the true pillar, but what are the main pillars of Niti Aayog? Tiketa apnaloke ebar sai jabo. Objective can be derived from that pillars only. Okay, so if you remember those pillars, then this objective will definitely strike your mind wherever you try to solve that question. So always go for remembering the pillars, it will be easy for you also. In the Indian Constitution ensures individual freedom, social justice, community rights. Which of the following are, this is the easiest question, I think 1 2 3 all are correct. Which of the following events may lead to the loss of Indian citizenship for an individual? Indian citizen কি ক্ষেত্ৰত নিজৰ citizenship হেৰুৱাব পাৰে? When an Indian citizen voluntarily acquires the citizens of another country, this is correct. If the citizen has shown disloyalty to the Constitution of India and eto jodi proof হৈ যায় তেতিয়া if he is a minor whose parents have renounced Indian citizenship, নিজৰ parents সকলে বলে কি কৰিছে citizenship to বা ভাৰতৰ নাগৰিকত্বটো renounce কৰি দিছে, I am not a citizen of India anymore from I বা মোৰ spouse, ঠিক আছে, তেতিয়া in that case যদি তেওঁলোকৰ son বা daughter কি হয় minor হৈ থাকে, in that case also loss of Indian citizenship হ'ব পাৰে for that minor. Okay, so 1 to 3 all the statements are correct here. 96 schedule of question আকৌ উঠিছো, second schedule of constitution deals with the emoluments and privileges of speaker of the legislative assembly in the state, prime minister, judges of the high courts আৰু opposition of the lok sabha. So deals with মানে কাৰ কাৰণে applicable হয় সেইটো উঠিছো. Speaker of the legislative assembly in the states, yes. Judges of the high courts, this is yes. Prime minister and leader of opposition is not correct. Why? Because they derive it is silo. Second schedule of all these are permitted. Okay. President, governor, speaker and deputy speaker of Lok Sabha, chairman and deputy chairman of Rajya Sabha, speaker and deputy speaker of legislative assembly in the state, chairman and deputy chairman of legislative council of the state, judges of the Supreme Court, high courts and CAG. Okay. Prime minister is covered under purview of salaries and allowances of Ministers Act 1952. Leaders of opposition are covered under the purview on salary and allowances of leaders of opposition in parliament 1977. Okay. এবাৰ লোক আদালতৰ কথা সুধিছো, লোক আদালতৰ কথা, লোক আদালত. Okay. It has been given statutory status under Legal Service Authorities Act. Correct খুদিছে 1977. লোক আদালত, family court and the other ADRs তেওঁলোকে কোনটো এক্টৰ মতে ফাংচন কৰে সেইটো আপোনালোকে জানিব লাগিব. ওকে, the award আৰু এটা কথা, ফ্যামিলি কোৰ্টৰ এটা বস্তু ইম্পৰ্টেন্ট আহি যায়, পাৰ ডিস্ট্ৰিক্টত ফ্যামিলি কোৰ্ট এস্টাবলিশ কৰা কাৰণে কিমান পপুলেশন হ'ব লাগিব, আৰু এটা কোৱেশ্চন আহিব পাৰে যে পহে পপুলেশনটোৰ তলত যদি কোনোবা এখন ডিস্ট্ৰিক্ট থাকে তেনেকুৱা ধৰণৰ ডিস্ট্ৰিক্টত ফ্যামিলি কোৰ্ট এস্টাবলিশ কৰিব পৰা যাব নে নাই, আৰু যদি পাৰা যায় কাৰ পাৰমিশন কোনে ল'ব লাগিব. ওকে, there is no the award by the Lok Adalat is not binding and is appealable. So this is not correct. Okay, there is no strict application of process. This is actually amar heri kotha di dise, gram nyayalor kotha to di dise Lok Adalatot. Okay, there is no strict application of procedural laws like Civil Procedure Code, Evidence Act while assessing the claim of Lok Adalat. So these ADRs are basically established to make the procedural law flexible. Okay, the provisions like summary trials ebilak ahise because we are relaxing the procedural laws. So this option is correct also. So before studying Lok Adalat, before studying Gram Nyayalayas, before studying family courts, you will have to know the objectives of ADRs. Otherwise you will simply remember it and you cannot answer this question, the statement based questions. Kihor karone no ami bonai asu Lok Adalat, kihor karone ami family court bonai asu, we have judiciary, but why we are going for ADRs? Okay, aru ADRs to akor reform hoise niki, is there any reformation act, ekhini ami sabo lagibo. So 1 and 3 are correct only. Okay, so statement 1 of kotha ami already poilu. According to the Supreme Court, the benefits under Lok Adalat are there is no court fee and court fee is already the amount will be refunded to the dispute settled in Lok Adalat. The basic feature of Lok Adalat are the procedural flexibility and speedy trial of the disputes. There is no strict application of procedural laws like civil procedures that like CPCA hog, Evidence Act hog. The parties to the disputes can directly interact with the judges through their counsel, which is not possible in case of regular courts. Lok Adalat is a forum where the cases under disputes are pending in a court or which are pre-litigation stage. So gotike etu kotha hudibo pare ki Lok Adalator eta matter anibo karone is it mandatory je ami সেই matter to notun matter hisabe plus mane place korim, পুৰণা matter যদি pending আছে courtot ba তেনেকুৱা matter আমি Lok Adalator place কৰিব পাৰিম নাই, যেতি হেতু এটা question আহিব পাৰে. ঠিক আছে, তো award কথা যেতিয়া আহে, সো আপোনালোকে গম পাই ন ADR ত যিবিলাক কয় these are not মানে referred as verdict, these are known as award. Okay, The award given by Lok Adalat is binding on the parties. Okay, binding hoy, and it has the status of decree of a civil court and is non-appealable, which does not cause the delay in the settlement of dispute finally. Or this is very difficult. Now you can move to the move only in terms of writs or special leave petitions, right? I think I believe that you have heard about it. 98. Consider the following division of power of taxation between central and states. Okay, which of the following are correct? The power of taxation on subjects enumerated in the concurrent list lies exclusively with the parliament. No, the power to impose taxes on subjects not enumerated in any list is vested with the state legislature. Okay, so this is also not correct. So please note these points. Ki koy? Parliament has exclusive power to levy taxes on the subjects enumerated in the union list only. The state legislature code ase state list aru concurrent list jot both center to state law make koribo pare tate ki koise parliament and state legislature both can levy taxes in subjects enumerated in the concurrent list. Okay, kako preference diya in that case. The residuary powers of taxation is vested with the parliament. Under this provision, the parliament has imposed gift tax, wealth tax, expenditure tax, etc. Aru ki korise? The constitution also draws a distinction between the power to levy and collect the tax and the power to appropriate the proceeds of the tax. Okay, procedure of collection upor to eta distinction rakhise between levy and collect. Kune logabo, kune collect koribo. Okay, income tax is levied and collected by the center, but its proceeds are distributed between center and the states, respective states. Next, question number 99. The committee or commission was formed to examine thoroughly the various issues of center-state relation. It recommended the establishment of an interstate council under Article 263 of Constitution of India for first time. Now, generally, manu etu sarkariya commission boli likhi diya, but this is first ARC, Administrative Reform Commission. Okay, so the interstate council was set up in 1990 and the Ponsi Commission in 2025. So it is not possible that for first time Ponsi Commission would recommend the establishment of an interstate council. ঠিক আছে 2007 of established হয়েছিল Ponsi. Next, the commission was constituted by Government of India in 2007 to examine the center-state relation. It was option A, hekarne not correct. Interstate council set up in 1990, Ponsi Commission established in 2007. Gotike, this is not justified only. The Ponsi Commission backside time mission recommend koribo. ঠিক আছে? Khusro Committee is known for the Agriculture Review Committee. 1989 established হয়েছিল. So this is also not correct. Option D is not correct. The interstate council was set up in 1990 following the recommendation of Sarkaria Commission, but it was already recommended by the ARC in 1966 itself. Hey karne confuse kore. Okay, first it has been recommended by ARC only in 1966. Although Sarkaria Commission recommend korisile, but first Administrative Reform Committee was the first. Okay, eto confuse no koribo. Dinesh Goswami Committee, Bohra Committee and Kankha Committee are related to electoral reforms. I hope you have studied about it. Dinesh Goswami Committee ki koise was on electoral reforms in India, suggest ki koise providing state funding in kind of political parties. Also ki koisile a candidate should not be allowed to contest elections for more than 2 constituencies. This is very important, very important. Etu monot rakhibo. So which committee recommended that one candidate should not be allowed to contest from more than 1 constituencies, so more than 2 constituencies. So it is Dinesh Goswami Committee's recommendation. Okay, Bohra Committee report. It was submitted by former Indian Home Secretary N.N. Bohra, 1993. So criminalization of politics aru the nexus among the criminals, politicians and bureaucrats লগত deal কৰি এই কমিটিখনে report submit কৰিছিলে. আৰু কাংখা কমিটি যোনখন আছিল 2010 ত ওপেন কৰা গৈছিল. It was to look into the whole gamut of the election laws and electoral reforms. Okay, so আমাৰ 100 questions খিনি শেষ হৈ গৈছে. যিসকল বিগিনাৰ্স আছে মই আকৌবাৰ কম যে কেৱল statement based question লাগে, statement based questionত answer কৰিম, statement based question ঠিক কৰি আহিম, that is not correct. You cannot remember all the things. The syllabus is vast. Remember কৰা কাৰণে you will have to be conceptually correct. Okay, কিছুমান question যদি কিছুমান টপিক আপুনি স্কিপো কৰে, কিন্তু যদি সেই টপিকটোৰ ওপৰত আপোনাৰ নলেজ আছে, কনসেপ্ট আছে, you can directly catch that matter. For example, যদি আপুনি আপোনাৰ ADR ৰ কনসেপ্ট, অল্টাৰনেট ডিসপিউট ৰিজলিউশনৰ কনসেপ্টটো আপুনি ভালকে জানে, দেন লোক আদালত, গ্ৰাম ন্যায়ালয় বা ফেমিলি কোৰ্টৰ বহুত প্ৰভিজনছৰ কথা আপুনি জাস্ট ADR ৰ কথা ভাবি পেলাই আপুনি গম পাই যাব। মেথডছ বিলাক কোড কেনেকৈ এপ্লিকেবল হ'ব, you will get to know about it. But মুখস্থ যদি কিছুমান বস্তু কৰিব যায়, কাৰণ you have to remember a lot in certain cases, constitutional body, non constitutional body to কিছু বস্তু আপুনি ৰিমেম্বাৰ কৰিবই লাগিব। সো তাৰ ওপৰত যেতিয়া statutory body বাহি গৈ থাকিব, then how can you remember that? Okay, so এইবিলাক অসুবিধাৰ কাৰণে কনসেপচুয়ালি যাতে আপুনি পঢ়ি পেলাই in a minimal attempt, minimal wastage of time, আৰু ইমান ডাঙৰ বস্তু পঢ়াতকে strategic way যাতে ইমানখিনি পঢ়ি ইমান ডাঙৰ ৰিজাল্ট লাভ কৰিব পাৰে, তাৰ কাৰণে Sandpaper 1:1 প্ৰপাৰ মেন্টৰশ্বিপৰ আন্ডাৰত আপোনালোকক যেটো আমাৰ মে জুন বেচ হয় ৰেজিষ্ট্ৰেচন চলি আছে। Okay, we are expecting it on the 15th of June. নতুন যিসকল বিগিনাৰ্স আছে বা যিসকলৰ কনসেপচুয়ালি অলপ প্ৰবলেম হয় পৰীক্ষাত প্ৰিলিমছৰ কোৱেশ্চন আনসাৰ কৰাত, you must come here and you will know the difference how we taught. Okay, so মই সেইটো কাৰণে কওঁ যে প্ৰবলেমছ বিলাক আমি পৰীক্ষাৰ দিনা গৈ পেলাই পঢ়া টেবুলত বহি পেলাই ভাবিলে নহব। আৰু এনেকুৱা নহয় যে আমি এখিনি পঢ়া নাই। Yes, যদি পঢ়া নাই বা যদি পঢ়িবলৈ সিলেবাসটো ভাস্ট হৈছে, আমি সেই সিলেবাসটো স্ট্র্যাটেজিক্যালি কেনেকৈ মেনেজ কৰিম, that is the key question now, and this is the responsibility of ours to guide you. So that's why প্ৰত্যেকজন ষ্টুডেন্টৰ যি প্ৰবলেম থাকে, সকলোৰে প্ৰবলেম বেলেগ থাকে। কিছুসকলৰ টাইম মেনেজমেন্টত প্ৰবলেম থাকে, কিছুসকলৰ আন্ডাৰষ্টেণ্ডিঙত প্ৰবলেম থাকে, কিছুসকলৰ ট্ৰান্সলেশ্যনত প্ৰবলেম থাকে, টাৰ্মছত প্ৰবলেম থাকে, কিছুসকলৰ ডাউটছ বেছি হয়। ওকে, আমি সেইখিনি অপৰচুনিটি দিম যাতে আপুনি আহক, সোধক, যিমান পাৰে পৰীক্ষাৰ আগত সোধক। যেতিয়া এজন সিভিল সাৰ্ভিস প্ৰিপাৰেচন এনেকুৱা প্ৰিপাৰেচন নহয় কি আপুনি সব বস্তু জানিব, অনেষ্টলি। যদি আপোনাৰ সিভিল সাৰ্ভিস প্ৰিপাৰেচন কৰাৰ আগত ডাউটছ ওলাই, দিস ইজ এ গুড সাইন, কাৰণ সেই ডাউটছ বিলাকে কুৱেশ্যন হ'ব পৰীক্ষাত। এই ডাউটছ বিলাকে এনালাইটিক্যাল বেস কুৱেশ্যন আপোনাক সুধিব। সেইবিলাক যদি আপুনি নুসুধে তেতিয়াহ'লে কেনেকৈ হ'ব? ওকে, এই ডাউটছ বিলাক কেনেকৈ সলভ কৰিব? ওকে, আৰু তাৰ লগতে আপোনালোকৰ প্ৰত্যেকজন ষ্টুডেন্টৰ ডাউট বিলাক কেনেকৈ সলভ কৰিম, ডিফাৰেন্ট স্ট্ৰেটেজি লগাই তাৰ ওপৰতো আমি স্পেসিফিক ভাবে গুৰুত্ব আৰোপ কৰোঁ। ওকে, সো ইউ অল আৰ ওয়েলকাম, এণ্ড আপোনালোকে আমাৰ ব্ৰচাৰখন ইয়াতে ডাউনলোড কৰি ল'ব পাৰিব। দিস ইজ দ্য QR। আই হোপ ইট ইজ ক্লিয়াৰ। সো থেংক ইউ সো মাচ। আমি বাকি যোনকেইটা 100 কুৱেশ্যনছ আছে, ইকনমিক্স আৰু আমাৰ জিঅ'গ্ৰাফিয়ে হওক, 100 ইম্পৰ্টেণ্ট কুৱেশ্যনছ, আমি সেইখিনিও আপোনালোকৰ আগত লৈ আহিম। If you have any doubt, just feel free to get some guidance from this number. Okay, just you can call here, you can drop a text here if you are not comfortable calling us. Okay, just this is the number. I expect all to call here, text here if anybody has doubt. Thank you so much. যিসকলে প্ৰিলিমছ দিব আকৌ এবাৰ শুভেচ্ছা জনাইছো। কনফিডেন্ট হৈ যাওক, এইখিনি সময়ত অলপ নাৰ্ভাছ ফিলো হয়, বেটাৰ নকৰে। এতিয়ালৈকে যিখিনি প্ৰিপাৰেশ্যন কৰিছে জাষ্ট ৰিভাইজ কৰক, আৰু মই সদায় এটা কথা কওঁ, জাষ্ট থিংক দেট ইউ আৰ দ্য বেষ্ট। ওকে, এইটো ইগ' হ'ব নালাগে, দেট ইজ ফৰ সেলফ কনফিডেন্স। ওকে, ইউ আৰ দ্য বেষ্ট এণ্ড ইউ উইল ডু গুড। বিলিভ ইউৰ সেলফ, ট্ৰাষ্ট ইউৰ সেলফ। ওকে, থেংক ইউ এণ্ড হেভ এ নাইচ ডে।